The Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. Today is a very special day at the Appellate Division 4th Department as we welcome Craig Hanna, the Honorable Craig D. Hanna, to the 4th Department as our newest member. Judge Hanna was appointed by the Governor of the State of New York to this court 13 days ago, and this morning is his first sit with us. Judge Hanna, I regret to say we usually don't get standing room only crowds for our oral arguments. But these folks are here for you. We have your colleagues sitting in the front row and the staff, and they are here, all of us here, to welcome you on your first day. Judge Hanna was appointed Thursday, 2 weeks ago Thursday, and the following day he came to the Appellate Division here in Rochester for the first time. He was greeted by our presiding judge, Gerald Whalen. Judge Whalen greeted Judge Hanna in the same manner he greets all the other new members of the court, with a firm handshake, a warm smile, and a towering stack of briefs and records. After a tour of the premises, Judge Hanna got in his car, drove back to Buffalo, and I think his motor vehicle, was a little lower, closer to the thruway than it was on his way here. So it's been a busy 2 weeks for Judge Hanna leading up to this morning. By way of background, I can tell you that Judge Hanna is a 1995 graduate of the Law School of the State University of Buffalo. He began his legal career as an assistant district attorney assigned to the City Court Bureau, Buffalo City Court, and to the Grand Jury Bureaus. From there, he went to work for the Buffalo Law Department, City of Buffalo Law Department, becoming one of their top trial lawyers. He also then served as legal counsel to the New York State Senate, and he also operated his own law practice. In January 2006, Judge Hanna was appointed by the mayor of the city of Buffalo to fill a vacancy on city court. He was elected that November to a full term, garnering close to 80% of the vote. Judge Hanna was reelected to a 10-year term, another 10-year term in 2016, and he then became, a few years later, the chief judge of the Buffalo City Court. He was also served as supervising judge of all 11 city courts in the 8th Judicial District. While in city court, Judge Hanna presided for a number of years over the drug treatment court. He also served as an acting Erie County Court judge and acting family court judge. Now, it's customary in these first sit proceedings to go through all the awards the new judge has won. I can't do that this morning. If I were to list all the awards that Judge Hanna has won, has been given over the years for his work on the bench, we'd be here past 5 o'clock. And I'm not talking about today, 5 o'clock. I'm talking like Thursday. It's truly amazing, the recognition that he's received over the years for his work on the bench. I can tell you that, just to pick a few, he received the Outstanding Jurist Award from the Erie County Bar Association, 2018. He also received the Outstanding Jurist Award from the New York State Bar Association, covering the entire state, of course. He served as the president of the Minority Bar in Western New York and received his Legal Service Award as well. For his innovative work in drug treatment court, Judge Hanna received nationwide attention media coverage. Articles are written about him and his work in the New York Times, various other national media publications. Judge Hanna is a native of Western New York and a proud graduate of the City Honors High School. He is joined virtually by his wife Angela, is watching from home, and his daughter Taylor Marie, who is a student at the University of Buffalo. Craig, on behalf of the presiding judge, all our colleagues, and the entire staff here at the Appellate Division, wish to welcome you to the court. We are all very thrilled to have you.
Thank you.
We will now carry on with the business of the court. The first case on the calendar for oral argument is number 311, People versus Leroy Williams. 311. Good morning, counsel. You may proceed.
Good morning. May it please the court? Welcome, Justice Hannah. In this case, I'll start where I must start, the appeal waiver. It is a disputed appeal waiver in this issue. We submit that the appeal waiver is not valid, neither the written waiver or the oral waiver, but I would submit that this court doesn't actually have to address the validity of the appeal waiver because Supreme Court, during the colloquy, informs Mr. Williams that you can still appeal any speedy trial rights. He didn't say constitutional speedy trial rights, he used the word any. And in this context, any means either your statutory speedy trial rights or your constitutional speedy trial rights. And there's another factor in the plea colloquy that really enforces the interpretation of the word any to encompass the statutory speedy trial rights. And that is that Supreme Court issued Mr. Williams a decision on his statutory speedy trial motion just 4 pages earlier in the transcripts. So Mr. Williams has just had his statutory speedy trial motion denied, and then Supreme Court tells him, and you can appeal any speedy trial rights. So I think that that clearly, as far as Mr. Williams' understanding, that clearly accepts the speedy trial argument raised on appeal from the appeal waiver. If there are no questions about the appeal waiver, I would move to the denial of the speedy trial motion.
Please do.
And in this case, we've got a LaFontaine issue. Supreme Court, when he's denying Mr. Williams' 3030 motion, he says, I issued a decision previously in the Turner case. He says, that's the decision I made previously. I'm going to stick to that decision in this case.
Ms. Weiss, do you think the AG's office should have been put on notice when the defendant challenges the constitutionality of an executive order?
Yes, Your Honor, and they were in this case. The affirmation of service was erroneously not included in the record, and if this court would allow me, I would submit as a supplement in the appendix that affirmation of service.
Were they placed on notice of this appeal?
Pursuant to this court's rules, they were provided with a copy of the brief.
Okay. So your position on LaFontaine is that Judge Schiano, when he denied the motion, this was right before the plea, the motion had been outstanding, and he said, by the way, I'm going to deny it for the same reasons as in People versus Turner. It was a separate case.
Correct.
But in Turner, it didn't address, your position is that Turner didn't address the constitutional issues that your client's lawyer had raised.
That is correct.
Here. So you're not saying, the way the people look at it is that your client pled guilty before he had a ruling on the constitutional issue, and therefore it's forfeited. You seem to be arguing we can't affirm on the constitutional issue because it wasn't decided below. But how do you deal with the fact that he pled without a ruling on that issue?
So I would disagree that he pled without a ruling, and I would note that on page 10 of the respondent's brief that they concede that this is a decision, that Supreme Court denied the motion. And Supreme Court does not say, I find that the executive orders are constitutional. And that's precisely why we have the LaFontaine problem in this case. But Supreme Court, for a number of paragraphs in the transcripts, talks through why he's denying this motion. So I don't think that Mr. Williams failed to seek a motion. You can only, you file your motion, you file the reasons that support your motion. The court denies that motion. It is not incumbent upon Mr. Williams at that point to say, Your Honor, you didn't really address what it was. And in that context, there wasn't a timeout to say, let us see a copy of the Turner decision
Right. Yeah,
on which you are.
Yeah, I agree with you. It'd be kind of unreasonable to say the defendant forfeited his constitutional issue, which he raised. The court denies the motion as if he's familiar with the court's decision in Turner. I get you there, but what would you say to the possibility of, well, Judge Shiano's never ruled on the constitutional challenge to the executive orders. We remit it to Judge Shiano for a ruling in the first instance.
That is what I think is appropriate in this case. I think pursuant to LaFontaine, this court can't affirm on the basis that Supreme Court gave, which is the Turner decision. Turner decision doesn't rule on this. So this court can't affirm on that basis under CPL 470-15, and that's why we would submit that this must be remitted to Judge Shiano so that he can rule on it in the first instance, as the CPL requires, and then it can come back up to this court, after there's a ruling on it, and the affirmation of service can be properly filed with this court.
Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. Lisa Gray for the People, and welcome, Justice Hannah. Just with respect to the waiver of appeal, the written waiver of appeal in this case closely mirrors and tracks the model colloquy on the waiver of appeal. Moving on from the waiver of appeal with respect to the 3030 decision.
Counsel, before you get to the merits of that, do you agree that the Attorney General's office was on notice of that contention?
I do not believe that they were on notice. The copy of the brief was sent to the Attorney General's office, I think only with respect to the point 3 of the brief, which is the constitutionality of the criminal possession of a weapon statute argument that was being made. And I know that the Attorney General's office declined to intervene, but I do believe that they should have been on notice with respect to the constitutional overreach argument that's being made in point 2 of this
Now,
brief.
Ms. Weiss indicated that that notice was given to the AG.
As far as I can tell, I did not see any notice given, other than a copy of the brief had been sent with respect to point 3, the issues raised in point 3.
Well, regardless if it was sent or not, do you think that CPLR 1012B requires the AG's office to be put on notice?
I do believe they do need to be put on notice.
What about with the Court of Appeals decision in Clark, where they indicated that the law is from the legislature and not from the executive branch? Wherein CPR 1012 indicates that service is required where there's a constitutionality question on a law or statute, and executive order is not that. It's not a law.
It is not. You're right. Obviously, you are correct, Your Honor. I guess with respect to the fact that it is a constitutional question with a constitutional dimension, these are executive orders that have come down from the governor and not necessarily statutes or regulations, but because they do have a constitutional dimension.
But regardless, you say that they should receive notice on this.
I think so, Your Honor.
So what if they did receive notice on this? As
Well,
Ms. Weiss indicated.
I think at this point, whether or not this court addresses the issue of the constitutional overreach of these executive orders, I think this court can deny that claim. Although there seems to be a dearth of case law with respect to the constitutionality of executive orders, specifically with respect to tolling of 3030 time. There was a case that's cited in the People's Brief from 2002 that came out shortly after the attacks, the World Trade Center, post September 11th, where this almost exact same issue was raised. And in terms of, these 3030 tolling provisions being a constitutional overreach. And in that case, that claim, that issue was denied. I think for those same reasons, this court can also reach that issue if it in fact deems that it has the authority to reach the issue based on the rationale that was put forth in the case that's, I want to say it's pronounced Haniff, I'm not
So it's your
exactly
position that the AG was not put on notice in that regard? Are you indicating, would you in agreement then that the defendant herein waived that right?
I believe that they did.
Can I just clarify, though,
Sure.
you're talking about the brief was sent to the Attorney General. Are you talking about on the Bruin issue, on the weapons issue? Or, because we have two constitutionality issues. What if it sounded like they provided notice to the AG on the weapons challenge?
They did.
Second Amendment. Did that include the challenge to the executive order?
To my knowledge, it did not. Again, it's a little unclear. I know that the Attorney General's office received a copy of the brief, and they did not decline to intervene as with respect to the Bruin issue raised in point 3. But it was silent, the correspondence from the AG's office was silent as to with respect to the constitutional overreach argument that's raised in point 2.
Do you see any great harm in remitting it for Judge Shiano to make a ruling in the first instance?
I mean, the question posed is, do I see great harm? But I don't necessarily think that this court needs to remit. And one of the things that maybe wasn't made clear in my brief, and I'd like to take a moment to maybe clarify that, is that I think the Court of Appeals in People v. Nicholson has given the reviewing court the authority to rely on a record to discern any unarticulated predicate for a trial court's ruling. So in this particular instance, putting aside for a moment the fact that this issue was basically abandoned when the defendant pled guilty, and if this court wants to reach that issue of whether or not the threshold question of whether or not these executive orders were unconstitutional, Judge Shiano answered that in the negative. He answered that threshold argument, maybe not articulating it as such on the record, but when he denied the 3030 motion, he had to obviously reach that threshold question.
Sorry, Judge Lynn. Counselor, as I understand it, though, the contention that it's unconstitutional is because the executive order was overbroad, too. That it went too far, was too long, that Monroe County was back up with business, at least virtually, long before the executive order ran out. That would require factual determination, wouldn't it?
Well, I guess it depends, well,
I
suppose yes, but when you say back to business, go ahead,
But,
I'm sorry.
but as I understand it, is part of the contention here, that your office, if this is remitted, would have to put in proof that the executive order was appropriate under the circumstances, the scope and extent. You prepared to do that?
Well, I think the way it's framed from appellant's perspective is that because 18080 tolling was lifted before the tolling of 3030, that necessarily triggered speedy clock 3030 time. And procedurally, 18080 and 3030 are two totally different animals. So the argument that just because 18080 tolling had been lifted before the 3030 tolling, that somehow that triggered the people's speedy trial clock with respect to whether or not the accusatory instrument should be dismissed because 3030 time had run, I don't think you can make that argument. So the court's ruling with respect to the time chargeable to the people, sort of on its face, meets that burden in terms of calculating time for 3030 purposes. I think this court needs to kind of put aside this idea that because 18080 was tolling was lifted before 3030, quite frankly, I think that's a bit of a red herring when trying to determine 3030 time, because the tolling that's lifted for 18080 in Monroe County, that date is not dispositive or does not play into the analysis of the calculation of the 3030 time. So to answer your question is no, I don't think so. I think on the record before you, you can see on its face the time that's chargeable to the people, the time that is tolled, which is not chargeable to the people, and to make the calculation that the people were ready for trial prior to the expiration of the 3030 clock.
All right, thank you, Counsel.
Thank you.
Case number 313 is People versus Jeffrey Williams, 313. Counsel is appearing virtually. You may proceed after you unmute yourself. Counsel, you need to unmute. There you go.
Sorry about that.
No problem.
Good morning. May it please the court. Thomas Pelch on behalf of Jeffrey Williams. Mr. Williams has requested that I respectfully mention to the court that he submitted a pro se supplemental brief, and he kindly asks the court to give consideration to the arguments he's made. particularly with respect to probable cause. As long as the court doesn't have any questions for me, I would like to rest on arguments contained within the briefs. And if the court does not have any questions, I would kindly give back any additional time.
Thank you, Counselor. Mr. Tantillo?
Thank you, Your Honor. Good morning. My name is Michael Tantillo for the respondent. In light of counsel's submission, I would be happy to do the same unless there are any questions from the court.
Hearing none, thank you.
Thank you.
314 is People versus Roger Wiggins. Good morning. Mr.
Good morning. May it please the court, welcome Judge Hanna. I'd like to focus on point number 2. The search warrant in this case basically authorized the search of cellular phones, including contents. What content?
Is that overbroad?
Overbroad, lacks particularity, gives the police unfettered discretion to rummage through the entire cell phone without any time limitations. It's an unconstitutional general warrant. No crime was specified. There was no description of any probable cause to believe that evidence of a crime would be found in the defendant's cell phone. No description of the items to be seized, no time limit.
If Investigator Mazzola's affidavit was incorporated into the warrant, it would cure all these problems you're talking about?
I believe not. I would argue it's not properly incorporated.
No, I'm saying if it were to have been.
If it were, I think we still have a problem that, looking at the language of the warrant and the affidavit, it's still authorizing search of cellular phones, including contents. It doesn't say a particular item that is in the cell phone that there's been probable cause for any search to seize that item. For example, there's no probable cause in the affidavit that says that the cell phone we expect to include evidence of internet browsing history that would be tied to this particular crime.
I guess your point is that they did have probable cause to look for text messages and phone calls, but you don't need to search, you don't need to go through his search history to do that. That's a separate search than looking for the text from the victim and the phone calls.
If the search warrant had said had directed the officers that were to execute the search warrant, that they had to look to the affidavit to limit the scope of the search, the people would be in a better position with respect to the text messages. But that's not what the warrant says. The warrant identifies the basis for issuing the warrant was the affidavit, but it doesn't say, officers, when you are executing this warrant, you must look to the list of items that are contained in the affidavit to get particularity and to cure the overbroad nature of the warrant. There's no deliberate and unequivocal language of incorporation. But even if there were, even if we consider both together, the warrant authorizes a search of the whole phone without date limit. There's no language in the warrant or the affidavit that says, okay, we have probable cause to search for text messages, internet browsing, this or that, and then this court can then sever and say, okay, well, at least you get the text messages. There was no request by the people for a severance of the warrant. There's no language in the warrant that would allow that severance. And on that basis, I would ask the court to find that it's an unconstitutional general warrant.
Thank you.
Good morning. I understand the court's concerns with regard to this warrant. I would just like to start off with, I do believe this is sufficiently incorporated, and it does satisfy the GROW requirements because we know who made the affidavit. By the judges, within the judge's warrant, it says it was made by Investigator Mazzola, the date it was signed, and that it was in front of her, and in essence, it was the basis for the warrant. And I think that under those circumstances, it can necessarily be inferred that it was attached to the warrant, because based on what she says. So I do believe that the affidavit is incorporated, and so from there, then we go to whether or not it satisfies the particularity and
You would
overbroad.
agree that, I think what Mr. Jurgen's argument is that when the officers execute the warrant, they need Investigator Mazzola's affidavit to make sense of what the scope of their search is. He says even if they have that, they went too far on the phone, but your point seems to be the warrant does reference the affidavit?
It identifies that it's based on it.
Yeah, says based on it in the first sentence, the first paragraph. But then you're saying it must have been attached, because again, when the police go to search, they need to have something in hand, okay, how far are we gonna go, what are we gonna do here?
Correct.
But it's not 100% clear that the officer did have the
So,
affidavit.
and I can't tell you with 100% certainty, but I do think it's significant that this is a cell phone search. This isn't a warrant that's being handed off to narcotics to go bang down a search of an apartment. This is being sent to a tech guy who's going to do a data dump based on the language of the warrant.
And isn't that why you need the particularity, though?
And I do believe there is particularity in the warrant, although there are no date limitations. The only explanation I can give for that is this, and that is that this is a relationship between the defendant and the victim in this case. Where do you draw the line? They had been significant boyfriend-girlfriend, they were estranged. What would have been an appropriate date limit? Had this been a stranger murder, a stranger robbery, under those circumstances, an open-ended warrant to me, which would seem much more egregious, because you don't know how far back to go under these circumstances. I would like to address, and I know I'm very familiar with Clanton, and ask the court to consider harmless error in this case. And I think that, I don't contest that the waiver of appeal in this case is bad. Is insufficient for the defendant to have waived his rights. But I do have to, in able to prove harmless error, I have to get into the mind of the defendant. And in this case, when he pled guilty, he specifically indicated he was waiving the court's rulings. So I believe that if I have to show that he would have pleaded guilty, notwithstanding this alleged erroneous ruling, and we do stand on our brief that it was not an erroneous ruling, I think it's significant that he did go far enough to waive that.
Yeah, I would agree with you this. If there were a trial and this issue came up, it looks kind of harmless, that he's driving to Canada, he's got massive blood in his motor vehicle, he had been seen fleeing from the scene, they had text messages, he acknowledged to the police that she was in the car and he said that she somehow stabbed herself. The cell search information would be suppressed here. They would still have the observations of the blood in his car from the
Yes.
Border Patrol agent. So I would agree, but this is a plea, and as you know, to say harmless error on a plea is a rare thing.
It is a rare thing, and I'm aware of the dissent side of this court on the issue of harmless error when you're involving a plea. But in this case, the significance of the evidence is really not great in comparison. There's the victim's blood and there was DNA evidence in the car, so there is no doubt. There is no issue, based on the evidence in this case, that the victim was killed inside of the vehicle. There's no issue that defendant was the one who did it, because you have multiple stab wounds. It's not just one accidental stab wound. You've got his admissions of trying to buy cleaning fluid on his way to the border in order to be able to clean the blood up. If there is ever a situation where harmless error should apply, under these circumstances, given the overwhelming evidence, we submit that this would be the case. Absent any questions, I'll rely on my brief.
All right, thank you. Case 315 is People versus Samuel Shaw. Good morning again.
Good morning again. I'd like to address both the suppression and the sentencing issues in this case. I'll begin with the suppression issue, and I think I have to begin with standing for the suppression issue. In this case, we submit that Minnesota versus Olson creates a per se rule that somebody who's an overnight guest at another's house has standing to contest the search of that house. And it's an undisputed fact here that Mr. Shaw was an overnight guest at Ms. McCoy's house. Supreme Court's or County Court's findings of fact established that he was an overnight guest. And in terms of, I recognize that Mr. Shaw bears the burden of demonstrating his standing, and that is sufficient in this case to demonstrate standing. Some other factors there is that he's a current overnight guest, unlike cases in which somebody has left after being an overnight guest. His status as a guest was not revoked. And in terms of the scope of the search, and therefore the scope of Mr. Shaw's burden of demonstrating standing, I would ask this court to reject county court's idea that the scope is the toilet tank. That's a misnomer, because to search a toilet tank, you have to be searching the bathroom. You have to be in the bathroom. So to require Mr. Shaw to demonstrate standing with that level of particularity is incorrect, because the greater includes the lesser. And the greater in this case is the entire home, including the single bathroom that was shared by all, presumably Mr. Shaw during his time as an overnight guest.
So if we get past the standing, we have the Peyton issue. Your argument is that it was constructive Peyton violation, if you will. There, if they went in and arrested him inside the house, they didn't have a warrant. That's a Peyton violation if he has standing.
That's correct.
They forced him out. In your mind, there's no meaningful difference between having a barricade armed and rolling over a fence and having guns pointed at him and order him out. It wasn't. He didn't come out voluntarily. Therefore, it should be treated as if he was arrested inside.
That's correct, and I believe that the Second Circuit says this the best. The rule in Peyton has zero meaning if the police can avoid that requirement by taking a SWAT team, surrounding the house with assault weapons and an armored vehicle, and ordering you out of the house. When that's a permitted way to get around the Peyton rule, what is the Peyton rule?
Counsel, address the attenuation.
Yes, Your Honor. So in this case, we have, I would say, a group of Fourth Amendment violations, including the Peyton violation, that come from this siege of the house. I would also note that it's not purely what some commentators would call constructive entry, but there's also 2 entries into the house itself, including Salvatore Amato, who testifies that he does a protective sweep inside the house. So we've got that same violation that's like from matter of Leroy M., and where the Court of Appeals addressed attenuation most recently. And in this case, even if Ms. McCoy's consent was voluntary, which we submit it's not, and I would like to discuss that as well, that consent to search, even if voluntary, is not attenuated from the Fourth Amendment violation. And it has to be both. It's not one or the other. The people's burden is to prove both voluntariness and attenuation. We've got Brown versus Illinois. That's the leading Supreme Court case that addresses attenuation. And we have matter of Leroy M., which is our state court case addressing attenuation. And each of the factors listed in these cases point towards no attenuation. So we've got temporal proximity. Here, Ms. McCoy's purported consent comes a mere 20 minutes after the SWAT team arrives and surrounds the house. They arrive at 8:45 p.m. Her consent is given verbally at 9:04 p.m., confirmed in writing at 9:08 p.m. That's taken from County Court's findings of fact on page 204 of the appendix. Next, do we have any intervening circumstances? And in this case, we don't. After the SWAT team kind of sieges the house, they walk into the house, they order Ms. McCoy and her young cousin, the 16-year-old, out of the laundry room. They lay on the ground, and their hands are handcuffed behind their back while they lay on the ground. They are then led outside, and Ms. McCoy is placed in the back of a police car. She gives consent while she's still in the back of the police car, still handcuffed, and you can watch Defense Exhibit B, which is a short body cam clip, which shows that she's surrounded by about 4 officers at the moment in which she gives consent.
How many times did she then testify, either the suppression hearing or the trial itself, my consent was voluntary?
She does testify that her consent is voluntary.
At least twice then, right?
Say again?
At least twice.
At least twice. And I think we have to look at Ms. McCoy's testimony in context. We have Nasser Zenilovic, who's one of the lead investigators on this case, and he testifies that the moment Ms. McCoy finds out what Mr. Shaw is accused of, she knows the victims' families, and she really wants to distance herself from Ms. Shaw. And I think her testimony at the hearing, it's very clear that she doesn't want to be connected to Mr. Shaw anymore, and her testimony is very unfavorable to Mr. Shaw, including saying that her consent was voluntary. But that's not dispositive in this case. We have to look at the objective circumstances. It's the totality of the circumstances kind of inquiry.
Your argument, as I read it, was that her testimony is not credible. Usually we have these consent cases, whether they're voluntary or not. The person comes in, the person consents to the search. Evidence is found. The person then comes into court and says, yeah, I consented, but it wasn't voluntary because I was afraid they threatened to arrest me, they threatened to arrest my child. That person comes in for the defendant and says, my consent was not voluntary. Here, it's unusual in that the person who gave consent comes in and says, for the people and says, yes, I gave consent, here's why it was totally voluntary. And then, as Justice Montour says, she follows it up at trial. So this is a little, I haven't seen a case like this where you're now saying her testimony is just not credible when she says, I consented voluntarily.
What I would submit to your honors is that Ms. McCoy's testimony that her consent is voluntary is outweighed by the other factors. And as this court, as Presiding Justice Whalen and now Judge Troutman wrote in their dissent in Freeman, which the Court of Appeals adopted, submission to authority is not consent. The Supreme Court has written the same thing, overbearing official pressure. And what we have in this case that I think outweighs Ms. McCoy's own testimony that consent was voluntary are these incredibly intense circumstances. And I will return to the attenuation, but shifting to discussing whether that consent was voluntary or not, we have Gonzalez from the Court of Appeals, 1976, and that gives us a number of factors. And the first factor in Gonzalez is whether the consenter is in custody or under arrest, and the circumstances surrounding that custody or arrest, also noting the large number of officers. And I think comparison of the facts in Gonzalez, in which the consent was found involuntary, to this case is instructive. In that case, the Gonzalezes were arrested. They're separated from each other. Ms. McCoy is arrested. She's separated from her young cousin. Her arms are handcuffed behind her back, just as in Gonzalez. And as many as 9 armed federal agents had swarmed about the small apartment. And here we have at least 15 SWAT team members in military garb with assault rifles, with their armored vehicle that crashed over the fence into the backyard and then ordered everybody out at gunpoint. That is a very intense arrest. That's about as much official pressure as I think you could imagine, unless you're calling in the National Guard. So that is the circumstances of her arrest, and she is still handcuffed in the back of the car. And I would just note that I know my opponent says she was not under arrest, but Nasser Zenilovich testifies on page 68 of the hearing that she is not free to leave. So she's in the back of the car handcuffed. She's not free to leave. After this incredibly stressful event, I would encourage the court to watch Defense Exhibit B. You can hear the timbre of her voice as she's speaking to the officers. She is incredibly upset. She is a woman who is crying or holding back crying. So I do encourage you to listen to her voice on Defense Exhibit B. That's one of the first Gonzalez factors. Handcuffing is considered a significant factor under Gonzalez. She is handcuffed. Was she advised of her right to refuse consent? Another one. No, she's not advised of her right to refuse consent. And is she experienced in dealing with the police? There's not much evidence about that, but of course it's the people's burden, so it was the people's burden to show that perhaps she was experienced with dealing with the police, but the evidence indicates that she's a mother of young children who's not experienced with the police. So I think looking at the flagrancy of the Fourth Amendment violation in this context, looking at the experience that she underwent, these factors that we look at under Gonzalez and under Freeman for determining whether consent is voluntary strongly outweigh her own representation that the consent was voluntary, especially when we know from Nasser Zenilovich's testimony that she's got some reasons not to like Mr. Shaw and not to want to do him any favors with her testimony. I'll return also to the attenuation, and I want to return to the purpose and flagrancy of the violation, which is one of the factors we look at for attenuation. And I think People versus Gonzalez, which is that Court of Appeals case about consent, has a line that I think is really appropriate for the type of Fourth Amendment violation here. It says, this was offensive official conduct, more suitable to a police society than to a policed society. And that's what I think this is. When you have a SWAT team surrounding a house, driving an armored vehicle into a backyard, you've got the assault weapons out, this is something that must be done with a warrant. And I think that this is a flagrant violation of the Fourth Amendment. And the flagrancy comes from the purpose of it. The officers testified that they intentionally did not get an arrest warrant because they wanted to interrogate Mr. Shaw.
Right. The ironic thing here is that they didn't get any admissions and the people didn't even use any of his statements at trial. So hindsight's 20/20, but they should have just gotten a warrant to begin with.
They should have gotten the warrant, and that they're strategically and tactically avoiding getting a warrant is what makes this so flagrant. And I would just note, part of the flagrancy analysis, in my opinion, is not just that Mr. Shaw's rights are violated, but Ms. McCoy and her young cousin, and in fact, the testimony shows all of the residents in the neighboring apartment, 24 at Kensington Court, they were ordered out as well. So you've got a whole group of people who are subjected to this really intrusive experience, being ordered out of their own houses and handcuffed at gunpoint. And that is That is not something that this court should endorse. And the twin purposes of the exclusionary rule are deterring police misconduct, but it's also judicial integrity. It's not putting the imprimatur of the courts on this type of flagrant conduct. So in this case, because we submit that Mr. Shaw has standing, because we submit that Ms. McCoy's consent was not voluntary, this court should apply the exclusionary rule to the fruits of that search, which in this case is the gun. Also, because of the group of Fourth Amendment violations, the entry of the house without a warrant before the consent, when Amato does the protective sweep, and when they come inside the house to get Ms. McCoy and her young cousin out of the laundry room, and then we look at the attenuation analysis. So that's why the gun and all the fruits of the search, the physical search of the house, must be suppressed.
Well, the only fruit is the gun, right?
I believe that is correct, Your Honor. That's the only fruit that is admitted at trial.
Wasn't the evidence rather overwhelming, though?
So the people do submit that this is harmless error, and I think that this court needs to reject that. If this court agrees with me that the fruits of that search need to be suppressed, the gun is the basis for counts 7, 8, and 9. So if that gun is suppressed, those counts need to be dismissed. But I don't believe that those counts can be dismissed and the remaining counts left in place in this case. And that's because the forensic evidence relating to the gun was really part of the backbone of this case. You have a magazine and shells that are found at the scene. The magazine is matched to that model of gun. And they also do the forensic analysis to determine
Aren't there witnesses that identified the defendant as the shooter?
Yes, there are eyewitnesses. But the people in their closing emphasize this is the gun that committed the murders at 670 Thurston. And there is a strong reliance on this forensic evidence. And this would be a very different trial without the forensic evidence, because in that case, you've got your eyewitnesses, and it's essentially going to be about the credibility of those eyewitnesses without the forensic evidence that is corroborating.
So wasn't that credibility challenged at the lower level?
The credibility was challenged at trial, but when that credibility is strengthened by the forensic evidence in the case, I think that is not harmless error. And I think this court should, if it does grant suppression, should not find that this was a harmless error. Again, at least 3 of the counts have to be dismissed outright in this case.
Thank you, counsel.
I would like to address sentencing, if I may, Your Honor. Of course, we submit that reversal is required. But if this court did not reverse, there are crimes and there are people for whom life without parole may be an appropriate sentence. It's not this crime, and it's not Mr. Shaw. Mr. Shaw does not deserve to die in prison. And I think it's interesting that this sentence is called life without parole, but it's really death in prison is what this sentence is. The legislature has authorized a range of sentences for this offense. They recognize that some crimes are more deserving of condemnation than others. Some people are more deserving of condemnation than others. This murder is a revenge for a prior robbery and a prior shooting. It just doesn't fall into that category. Mr. Shaw, with a minimal criminal history, his most serious prior crime is a misdemeanor DWI, is not somebody who's incapable of rehabilitation. Is not somebody who deserves never to have a second chance. We often talk about just the black letter law, this court can modify a sentence even if the lower court has not abused its discretion. The people note that the court didn't abuse its discretion, and I think it's important to remember that this court can just substitute its discretion. If a quorum of this court decides that a sentence of 25 years to life is more appropriate than life without parole, then that is what the court should be, regardless of whether county court abused its discretion or
Well, the
not.
court could say 40 to life,
That's correct,
or
because
consecutive.
if this court did not reverse, the sentencing on count 9 can be run consecutive. So this court, as it modified a sentence, would have the option of anywhere from 15 to life to 40 to life that it could modify the sentence down to. As Mr. Shaw's trial attorney asked for, we are asking for a sentence of 25 years to life. Mr. Shaw would be 57 years old at his first opportunity to appear before the parole board. And the parole board is not releasing everybody on their first date, especially not with serious crimes. And if Mr. Shaw is ever going to be released, he has to earn it. And what I'm asking this court to do is to give Mr. Shaw the opportunity to earn it, the opportunity to appear before the parole board and show that maybe he's somebody in his 60s who can come back into society and not die in prison. If this court has no questions, I'll rest.
Thank you.
Thank you.
Good morning. Martin McCarthy for the people. Congratulations, Judge Hanna. I'm going to start with standing two. Standing is the defendant's burden to prove, not the people's. In this scenario, the testimony was the defendant was at this residence, in essence, partying with the occupant, the woman who lived there. It sounds like at some point he passed out, went to sleep, and once he woke up, she wanted him to go. She wanted him to leave. And he was planning on leaving, and in fact, he was waiting for a ride at the time the police came.
But she did give him the consent to be there, didn't she? She said it was okay for him to stay, didn't she?
At the time he came into the house, yes, but she did expect him to leave.
Did she express that to him? No, she definitely testified that she wanted him gone, she had stuff to do, but was there some testimony that she said to him, hey, could you please go? Or anything like that?
It appeared that she was getting impatient with him, and also he had called a ride. He was waiting for a ride. His expectation at that point was that he was leaving, not that he was staying. This is not a scenario where somebody's in a house sleeping as an overnight guest when the police arrive. This is not a scenario where the police arrive, while the guest, sort of checks in, if you will, and is going to go to sleep. And this is not a scenario where the individual was sort of eating breakfast after having gone to sleep and was just waking up. This was, he had been there, the whole day, and he was planning on leaving. He was not planning on staying again. So when you talk about overnight guest expectations, did he have overnight guest expectations at the time he got to the house? Yeah, I would say so. And so would Minnesota versus Olson. When he was sleeping, yes. When he woke up, yes. When he maybe took a shower, yes. But when he's waiting for a ride to go, no, because he's not staying another night. He's leaving. So his expectation of privacy ended at that point.
What about the consent issue? Assuming that the Payton issue goes against you, did your office prove Ms. McCoy consented beyond a reasonable doubt to the search?
Yes. Yes, we did.
Was she in handcuffs? I know she was in handcuffs when she was taken out and so forth. Were the handcuffs on when she gave consent?
The way I recall it, at the time she gave consent, no.
They took the handcuffs off and they explained, we're not here for you.
Yep.
They explained the nature of the investigation, and it sounds like her attitude switched over from being anti-police to being
Anti-him.
Mr. Shaw.
Because he took a gun into her house.
And had killed friends of hers.
Well, I don't know if, yeah.
She said that she was friends with.
Yes, and she definitely testified to that at the hearing. So when you look at that scenario, like, she doesn't want a gun in her house. Like, counsel spent a lot of time talking about her lack of experience in the criminal justice system. I don't have any experience as a defendant in the criminal justice system. If I found out somebody brought a gun into my house, I wouldn't want the gun in my house. It's a natural reaction. Don't get that gun out of my house. I don't want it.
She's got kids in there.
She's got kids in there. That's insane, right? So, yeah, it's to say that her testimony was incredible on that. To me, it's entirely credible. It entirely makes sense that she would consent under that scenario. And lo and behold, they found a gun. They found a gun in the bathroom, not in an overnight bag, not in a dresser drawer, in the inside of a toilet tank that anybody could have removed. There was no indication that that was sort of his personal space where he could put a gun.
Counsel suggested this morning, and in her brief, that Ms. McCoy's testimony at the hearing that she voluntarily consented, she said, yeah, I consented to it, I had no problem with it, is not credible. We shouldn't credit that because she had reasons for being hostile to defendants, seeing that she had killed people that she knew. Would that not also be a factor in concluding that she voluntarily consented to the search?
Absolutely. Absolutely, in that scenario. Because, once it became clear that that was the issue, then of course she's going to say, I'm not going to hide anything for this guy, right? When you look, and you brought up, Justice Lindley, that's sort of the classic consent case where the witness usually comes in and says, I didn't really consent because A, B, and C. And then there was some relationship with the defendant where you could see that, yeah, maybe they wouldn't consent because they wouldn't want to get that person into trouble. right? That's usually how this fact pattern goes. That's not what happened in this case. She definitely wanted to get this individual, she wanted to get Mr. Shaw into trouble. She wanted that gun out of her house, and this guy had killed a couple of her friends. So yeah, that's actually a factor in favor of voluntariness, not a factor in the opposite direction.
But he was under arrest when she gave the consent, right? They had already arrested him. They made him come out, they arrested him. And
yes.
then they take the handcuffs off her and ask her to consent?
Yes, I believe so. And so, you know, they have him arrested, they ask her for consent. So in a sense, he's not a threat to her anymore, but there's still that gun in the house. That's a threat to her.
But she doesn't know if there's a gun in the house.
They-
They're telling her they think it might be.
And that was enough for her to jump at the chance, which is how it was described. When the police described how she consented, they said that she jumped at the chance. And when you listen to her testimony at the hearing, it's clear that assessment by the police officers was accurate. She definitely did jump at the chance to get that gun out of her house.
Because she knows then it's not about her and they're not going to arrest her
No, yeah.
in the presence of her children and her
It's his
cousin.
gun. And it's his gun, all right? So that's really was her approach to that, was that's his gun, that's his problem. He did that thing, he shot those people, that's all him. I don't, one, want anything to do with it, and two, yeah, I'm hurt too that he killed those people that I knew. So yeah, I want you to go solve this crime. I want you to get that gun.
Now, the
To me,
police-
that's entirely reasonable.
Police could have gotten an arrest warrant. They also could have gotten a search warrant once they arrested him outside. There were two opportunities to get warrants, and we wouldn't be here on those issues. And they elected not to go to a judge and get a warrant for the house or for his arrest.
Okay, so dealing with the arrest warrant first, the Court of Appeals has repeatedly held that there is no requirement that the people get an arrest warrant to arrest a defendant. That argument has been up at the Court of Appeals several times now.
Even if it's their intent to
Yes,
to evade his right to counsel. That's been
they have not decided that issue, so I would say yes. That's still the law. And even in this scenario, again, there were no statements, as you pointed out. I do also want to talk about the issue of Peyton, too, with respect to his arrest. His arrest, again, there was nothing seized as a result of his arrest, right? So whether he's arrested inside the house or outside the house, it really doesn't matter because there was nothing seized from him as a result of that. They didn't get a statement from him. They didn't get any physical evidence off to him that they used at trial. This argument that he was constructively seized inside the house actually wasn't argued below. When the evidence revealed that he was outside the house, the defense counsel didn't make the argument, oh, but he was constructively seized while he was inside the house. That's a new argument to be raised on appeal. And I just want to turn to harmless error. It's more than what counsel has described. The forensics did not just include the gun. Yes, the forensics with respect to the gun, they were able to match the projectiles to the gun. However, you take the gun out of the equation, what they had left was the projectiles. The firearms examiner would have been able to testify that those projectiles came from that class of gun. And the finding of the magazine, which is with his fingerprint on it, at the scene, which would have matched that type of gun that was found. And the box that he bought the gun, they recovered the box, and that had his fingerprint on it too. So in terms of all the evidence they had in terms of forensics, they had a lot more forensics than just the gun. They had witnesses who saw him shoot a handgun. They had the evidence of those projectiles. You have affirmed criminal possession of a weapon cases in which there had been no gun recovered. This would be a similar affirmance if you were to find that the gun should have been suppressed.
Do you want to close with any words on the sentence, life without possibility of parole?
Well, yes, I do. I'll keep them brief. Life without the possibility of parole is appropriate in this case. And the reason why is the defendant he ambushed and executed two young men who were sitting in a car, and he shot and paralyzed a third woman. She's sentenced to a life without an ability to walk ever again. Let's think about her for a minute. She's part of that sentence when you consider the sentence in its totality and the conduct, the heinous conduct that occurred in this case. Those two young men didn't know it was coming. This defendant shot multiple shots, not only killing them, injuring another individual. Lucky he didn't hurt or injure anybody else in this shootout. That conduct is reprehensible. That killing two people, the legislature has made that a murder in the first degree charge, and they've left it with the possibility that if you were to commit such crimes, that you would be sentenced to life without parole. And we have a violence problem in the city of Rochester, and this type of thing it happens a lot. And to kill two people, we just had a trial in Rochester where two young men were murdered in a drug war. And that individual was facing murder in the first degree, and I guarantee you that prosecutor is going to be advocating for life without possibility of parole. People shouldn't go outside with guns executing individuals because they feel like they've been wronged and injuring innocent people and paralyzing them for life. I say the sentence is entirely appropriate.
Thank you.
Thank you.
Case 316, matter of Antonio S. We're going to call that with 317, 318, and also 324.
And 23.
And 23. 5 cases, same counsel. Counsel for the appellant has submitted, we have virtual, we have 2 attorneys virtual. Ms. Mormon, you may proceed after you unmute yourself. You asking us to affirm in this case?
Yes, we are. Thank you, Your Honor. I believe today, unless the court has any specific questions for me regarding the person legally responsible question or the domestic violence questions, I think I'd like to just move on to discuss the violations of the orders of protection.
You may.
Thank you, Your Honor. So I would note for the court that the appellant here, Renee Gonzalez's own testimony from the hearing that he frequently took these children to the park and other places in violation of the orders of protection. The bottom line here is that orders of protection and violations of those can be executed on by law enforcement at any time via no-knock warrant or an ongoing violation, which Mr. Gonzalez clearly admitted here. And even if it's law enforcement's policy, as I understand it is in most cases, not to execute on those situations when there are children present, to place that, placing them at risk. There's a very strong chance that they won't always be aware that there are children in the home or otherwise near the person that they're looking to arrest. As stated by Sergeant McHenry from the Hornell Police Department, these situations can be extremely scary and dangerous to a child. They have their weapons drawn. They're looking for a person who has known violent tendencies, and they're kind of on the defense, not even sure if that individual might use the children, in order to keep themselves safe. Anyone who would violate an order of protection regarding the children might well do that. So Mr. Gonzalez in this case repeatedly violated the orders of protections. He admitted that there was much testimony to that effect. He violated the orders because it suited his own purpose, not for any real reason. That alone, in my opinion, should be enough and be sufficient for a finding of neglect. And when that's combined with the domestic violence that was also testified to in this case, I believe that this finding should absolutely be upheld. And there's really no reason why a person who's actually the person the order of protection is, again, shouldn't be held just as responsible for that violation as another parent who allows a person to be in the home, as has been held to be a valid reason for a finding of neglect.
Thank you, Ms. Mormon. Ms. Bendick?
May it please the court, for the children, Justice Lindley, I don't have anything to add to my brief unless the court has questions. I would like to extend my congratulations to you, Justice Hannah.
Thank you very much.
Should I remain on for the next case, Judge?
Yes, please. All right, we will now call 319, which is Hudson versus Carter, 319. Ms. Plank is here in the courtroom. Mary Hope Benedict is virtual.
Okay.
Good morning.
Okay, good morning. May it please the court. Tanya Plank for colleague Hudson. Congratulations, Justice Hannah. Okay, there was no sound and substantial basis for the referee to deny Mr. Hudson's petition to modify the visitation order on the grounds there was no change in the circumstances. There were, in fact, two big changes in the circumstances, and the biggest being that Ms. Carter moved to Arizona without the consent of the court, without the knowledge of Mr. Hudson, and she took the children, and until the judge ordered her to, she didn't even give Mr. Hudson any of her contact information. And the judge had also found, and I believe this goes against the trial testimony, only Mr. Hudson testified at trial. He said that he saw the children at least twice a week in public for 3 hours, getting pizza or going to the park. This completely complies with the order of visitation from June of 2021. And since he complied for 6 months until she moved to Arizona and he could no longer comply, that constituted a change in circumstances. And so, and the judge did no best interest of the children analysis. And I believe the case law says that visitation is in the best interest of the children unless there's some showing that there would be harm. And there's no showing here that there would be harm to the children for giving the father visitation.
The judge seemed to suggest that perhaps a contempt proceeding, the mother just moves out to Arizona without notice to anybody.
Right.
And the judge had said that may be the subject of a contempt proceeding. Has one been filed?
Not to my knowledge, no.
Is the mother still out there with the kids?
Yes, to my knowledge, she is.
And the court did then, despite saying no change of circumstances, the judge did change the visitation access.
She did, she
which is
granted
kind of
him
inconsistent.
remote, right, she granted him remote visitation, but no in-person visitation, which I would argue that's very important to have in-person visitation the father should have in-person visitation. Remote isn't a substitute for that. But there was also on the record, the father said that he was having problems arranging with the grandmother to do the remote visitation,
Right, so the mother leaves for Arizona without notice.
Right,
He had, before that, he complies.
Right.
With the 6 months, you gotta do whatever you gotta do. He visited, he did everything.
Yes,
No
right.
problems.
Right.
She moves out there. She doesn't show up for the trial.
right,
She doesn't participate in this appeal.
right,
And your client wants to have some in-person
Right.
visits with he's not even saying, I want custody. He just wants to
Right.
see his kids.
right, he just wants to
Doesn't
see his
sound
kids.
terribly unreasonable.
Right, exactly. So, so we would ask this court to reverse the referee's decision and either grant the petition, his visitation request, or else remit it to the trial court so that they can come to a visitation agreement that includes in-person visitation. If there's nothing further, I'll rest.
Thank you.
Thanks.
Counselor?
Yes, thank you, Judge. I agree with the father on this. There was no showing that the presumption that it's in the children's best interest to have visitation. There's no showing that was rebutted. Clearly, these children had a relationship with their father, and what the referee did was actually reduce his contact by he had pretty extensive supervised visits. The mother testified that the mother said in appearances, she wasn't under oath, but they were seeing their father for weekends at a time at the grandmother's home. So unfortunately, my office was unable to make contact with the children. So I don't have an update, but I think on legal grounds, these children are entitled to have a relationship with their father. So I would join with the father's request either to reverse and remit to family court or to to make your own order of visitation based on what the father was asking for and what the mother, essentially agreed to in another appearance.
All right, thank you so much.
Thank you, Judge.
Case 320, Blanchard versus Moravia Central School District. Mr. Militello, good morning to you.
Good morning, Judge, and welcome, Judge Hanna. Christopher Militello of Costello, Cooney, and Fearon for the appellant, Moravia Central School District. This appeal arises from the denial of the district's motion for summary judgment seeking dismissal of the respondent plaintiff's claims that were brought pursuant to the Child Victims Act, alleging that the district is responsible and should be held liable for abuse that he allegedly sustained at the hands of the elementary school principal from 1981 to 1983 while the plaintiff was a student at the Moravia School District. The district's appeal specifically argued that the evidence that was presented to the court demonstrated that the district had no knowledge that the principal had a propensity or was actually engaged in the abuse of any children. And we believe that the evidence that was submitted to the court was sufficient to make that showing. And in fact, the court's decision on the summary judgment motion acknowledged that the district had brought forward sufficient evidence to meet the burden of a prima facie case in entitlement to summary judgment. The court then went on to find, though, that they believed that there were questions of fact as to whether or not the district had created circumstances under which it was reasonably foreseeable that the student was abused by this principal. And the cases that
But counsel, let's be clear. This is a six-year-old child who is not misbehaving in his classroom, is being called into the principal's office once a week, twice a week, 3 times a week, behind closed doors for 45 to 50 minutes. Those are the circumstances.
Those are the allegations that the plaintiff made in his deposition.
Right.
Yes.
And an ordinarily prudent, what's the standard here in the school district of an ordinarily prudent parent?
That of a reasonably prudent parent, exactly right. And if a reasonably prudent parent observed those circumstances, and by the way, there is testimony in the record from the plaintiff's mother that she was aware that he was meeting with.
That may not necessarily be reasonable under these circumstances, right? This is a child who otherwise had no reason to be in the principal's office once or twice a week for 45 minutes behind closed doors.
Well, the principal has, I think it's inarguable that the principal has, as part of his job duties, to meet with students, whether or not in a pattern or practice, as the plaintiff has alleged, that the principal could or should be
What could
meeting
possibly
like
be
that.
the pattern of coming down 2-3 times a week, 45, 50 minutes, being escorted by the staff person of the principal into this room without windows and cut off from anyone else?
Well, there's a couple of parts of those factual contentions that are in dispute, and I understand.
Well, the issue of fact is the summary judgment.
I was going to say, I understand that summary judgment is not the place to resolve issues of fact, but those conclusions are essentially assuming that there are circumstances like this that are happening that are not being perceived by the people around them or being reported on them.
Well, Counselor, there's another
There's
piece
testimony by the people, I apologize,
Yeah,
Judge.
you're right, but the custodian, Ms. Wade, testifies that the principal inappropriately was touchy-feely with other children.
I don't believe that was her testimony. I believe her testimony was that she had heard rumors in the community that he was touchy-feely. And there's a very big difference, I hope you would agree, with somebody saying, I had heard rumors about this, and her actually saying, I watched the principal touch a student inappropriately or something like that. And I'm fairly certain that if you go back to the record and examine her testimony, it will be based entirely on rumor, and that she had never once said that she watched the principal actually put his hands on a student in an inappropriate fashion.
Well, let's get back to what Judge Del Conte had brought up before. The allegations, these are just allegations that may not have happened, but the plaintiff alleges that when he was 6 years old, starting when he was 6 to 8, he was called into the principal's office 50 times, approximately
Yes.
50 times. Doors closed in there for a long time. At no point does the mother or the father get a call of any misbehavior or anything like that. If it's a reasonably prudent parent standard, and the parent, a reasonable parent is watching all this, so to speak, 50 times going in, for 45 minutes, door closed, no notification that the child's ever done anything wrong, would a reasonable parent would red flags come up for that parent? It's like something untoward might be going on in there. You would say no, right?
No, I might agree with you if that were the facts, but I don't believe that's the facts. I believe that the testimony that the plaintiff's mother gave is that she was aware that he was meeting with her on a day-to-day basis and actually went to the principal and confronted him and said, why is this happening? And when the principal said it's being taken care of, she never inquired again. And I think that the reason that that's an important fact and that it ties back to the knowledge requirement is because if the mother had been reasonably prudent in that situation, she goes to somebody above the principal and says, I have concerns that my kid is meeting with this principal and I'm not sure what's going on here. That places the superintendent on notice that he needs to do something, that he needs to find out why the principal is meeting with him. And that is the key piece of the district's case here.
Well, just a moment,
Yes.
As I understand this, then, your position is that the mother should have pulled the alarm? The classroom teachers shouldn't have said anything when the student was being pulled out?
Well,
daily? Through
first of all, there's no
through a
testimony.
PA announcement, right?
Yeah.
These are not referrals from the classroom teachers to the principal. They're apparently not inquiring, why is this non-disruptive child being sent to the principal's office once and twice a week? And by the way, the mother did respond eventually and pulled the kid out of school.
After he left, yes.
Yeah.
Yes, but before that, she inquired, got a response that I think all of us would agree, if you were a parent, would not be sufficient to you,
Right.
and did nothing to put the school on notice. And by the way, Judge, I just want to address quickly what you said. She pulled him out, and then she brought him right back to the school the next year with the same principal. So
But you
was there
that
really a
the mother,
concern there?
The mother did respond, you're correct. But respond to what? My understanding of the record was that she got a note, one note, said that their son was in the principal's office that day. One note. And she called up and the principal, she said, what's going on? The principal said, it's been taken care of. I don't think she testified, yeah, I knew he was going down there 50 times and staying for 45 minutes. I don't think she knew about that. So one note from the principal about one day might be a little different than repeated visits alone with this man.
Well, and Judge, I think what's important about this, though, is, I think the question was asked before about, shouldn't the teachers have seen something? Well, there is no evidence about what the teachers saw or did not see here.
Secretary was sitting there, though, right?
And the secretary testified that she didn't ever recall the student ever coming to the office. And again, Judge, I recognize that you would recognize that as a question of fact as to the dispute between her testimony and his, but it does go to whether or not anybody that was employed by the school who had a duty and the ability to respond to the situation actually knew what was going on. And I feel like this is
Wouldn't they have, if we're looking at the reasonable parent standard, couldn't you extend that to the teachers or to the secretary themselves? See, what's going on here? If this was my child, somebody, I'd raise some questions. Why is this child's not disruptive? He's not causing any problems.
Well, but on the law, Judge, I think that the problem for the plaintiff in that situation is that the cases that the trial judge cited, the Doe v. Fulton case and the Murray case, both involved abuse by people that were outside of the scope of a school employee. They were not school employees. And there is lots of case law, particularly from the third department, the Mary KK case and the DSCC case, that recognize that there's a difference between school employees who go through a very high standard vetting process, even back in the 1980s. They were fingerprinted, they were certified, and that doesn't even get to our negligent supervision claim that I'll talk about in a minute, about the process by which this person was hired. And when you go through that process, the law has recognized that the society has a right and a reason to repose trust in these school employees that are vetted and are put there for the purpose of trying to educate our kids in a very intimate setting. Teaching is an intimate enterprise where they have direct contact with kids on a day-to-day basis, and the process has been put into place to make it so that these people are trustworthy and that society from the outside can trust them. The difference between this case and the Murray case, for example, that the court rested its hearing on, is that the person who abused the student in the Murray case was an outside employee of the Research Foundation, was in to recruit high school kids into potential other opportunities. And the reason that they held the district in that case was because they didn't follow their own rules for interacting with people that they didn't know who they were. And in this case, you had a person who was unquestionably, there's absolutely no evidence in the record that John Hall was not a trusted person in that district up until the time that he separated from the district. And so the question becomes...
I don't believe there's any other evidence of any other student that had to come down to the principal's office being escorted into this private little room without windows for 45 minutes.
Perhaps there's not, but if you start from the default that the law says that we give trust to these school employees, then you have to show that they had some reason to suspect that this trusted employee was engaged in conduct that they needed to monitor and intervene about. And so our concern right now is that in the absence of being able to show that they have that level of knowledge or any level of knowledge about this person's propensity to harm a child, then the operation of the school under normal circumstances is what you would expect. And the superintendent wouldn't have a reason to come in and ask the principal, why are you meeting with the student all the time if they don't know it's happening?
Right, look, you're on more solid ground with respect to negligent hiring and supervision of Mr. Hall. The issue that a lot of the questions have been coming in is supervision of the plaintiff.
Correct. There's a good distinction in between those two standards.
I agree with you on the second issue, that supervision, they didn't have any reason not to hire him. They didn't know he had propensities along these lines. They had no reason to supervise him more closely.
But I have a question even on that. Didn't
Sure,
the
Judge.
state have a requirement that you're supposed to check the references on the negligent hiring? Did they do that with this principal?
They did, and not only that, they received numerous, and we went through in our papers the very numerous places from which they received references. A school that he had recently taught in, somebody who was familiar with his military service, his academic advisor at Cortland College when he was coming through school. So and this is 1971 too, so remember that the Child Victims Act has placed us in the position of trying to understand what the state of the art was back then. And we believe that what we've brought forward in terms of the evidence of the hiring is more than sufficient to meet the standard that the most recent Third Department decision in Dolores v. Wade identified as a school doing its due diligence to ensure that the person that they're hiring comes properly referenced and has no reason for them to question their background, which again all circles back to the idea of what was the school supposed to do to stop this circumstance. We have no evidence that anybody knew that this was happening, and I recognize that it's inextricably interwoven with the idea that he says this. If I had to say what I personally believe about this, I believe he may be inaccurate in his description of what happened, because there is no corroboration of it whatsoever.
He might even be lying.
Pardon me?
He might even be lying.
I don't know whether he is or he isn't, and I'm not going to call somebody a liar in open court that I don't know that to be true, but I'm going to say...
Right, those are issues for the trial. But
Exactly, that would be an issue for the trial, but in the absence of this, none of the cases that the court has cited to actually support the idea that a school employee who is alleged to abuse somebody doesn't have to show, or the plaintiff doesn't have to show that the school had some knowledge that their employee, the person that they had control over, was engaged in or had the propensity to harm somebody.
All right, thank you, Counsel.
So, thank you, Judge.
Good morning. Just to be clear, the standard is knowledge or constructive knowledge. And what we have here is a circumstance where over the course of 2 school years, the young student, was called down to the principal's office via the PA system. So there actually are facts in the record demonstrating that the teachers in those 2 school years did know that this student was being called down repeatedly to the principal's office, despite the fact that, as the plaintiff testified in his deposition, there was no disciplinary problem, he was not acting out in class. So what's going on? Why is he getting called down constantly to the principal's office when there's nothing going on in class.
He's 6
At the
years
very-
old, and he's 6 years old at the time. I mean, how
That's-
much trouble can he be getting into at that point in time?
Exactly. And there's also testimony that other teachers saw the plaintiff in the area outside the principal's office, noticed that he was there repeatedly. And that's on 401 to 402 of the record. And his testimony is they asked what he was there for, and he just shook his head and shrugged. And that's 402. In fact, even fellow students noticed that he was repeatedly getting called down and asked what he was in trouble for. So to the extent that my adversary is suggesting that the teachers during those 2 school years had no knowledge or constructive knowledge about what was going on, that's simply not supported by the evidence in this record. At the very least, there's questions of fact as to whether the teachers had constructive knowledge.
Well, they had enough knowledge that they should have drilled down. That's your point.
Absolutely.
They didn't have to know what was happening behind the closed door, but they had enough, there was enough information that they should have investigated or taken some additional steps.
Absolutely.
And the other point that you've made, I believe, is that the superintendent was almost absent. There's testimony that he didn't come around, he really wasn't supervising this principal, you let him run the school the way he wanted to.
Yes, that is the testimony of the, pardon me, that was the testimony of the, I believe, of Deffendorf, who was the principal's secretary, who herself, she was the one who was actually calling the plaintiff down over the PA system, and she never asked why he was summoned so often or why the door was closed. She saw that the door was closed when he was in there. And then there's also evidence in the record to suggest that this was not the normal procedure, or not a normal practice that should have been going on when a student was called down to a principal's office. I believe that was actually from the superintendent, who said it would be unusual for a student to be called down at least 50 times within 2 years without also then ending up in the superintendent's office. And he also said that the normal practice was that a teacher would send the student down, and if it was a serious situation, the teacher would escort him. But yet what we had here was the student being sent down to the principal's office so many times with nothing going on from the teachers.
Do you want to be heard briefly before you sit down? Council relied on the case of Murray and Fulton for the proposition. Those are 2 of our cases where the offending individual was not an employee of the school district. He seems to draw a distinction between that situation and here where Mr. Hall did work for the school district.
Well, what I would say is that to the extent that counsel is relying on those cases in the context of his brief, that's if there's no knowledge or constructive knowledge by the school. That's with respect to if the court were to find that there's no knowledge or constructive knowledge and that it's not needed and that it's the liability is premised on the school not having practices in place to detect the abuse. Here, of course, our first argument is that there was knowledge or constructive knowledge. But what I would say as to those cases is that this is a distinction that's strictly being drawn by counsel. There's nothing in those cases. I would ask the court to look at those decisions carefully. And in those decisions, the court in any of those cases is not specifically making a distinction that the abuser, the alleged abuser in those cases, was not an employee of the school. I would also ask the court to look at the Doe v. Whitney case, which I know is a second department case. But again, it's applying all of the same exact principles. And in that Doe v. Whitney case, it actually was a first grade teacher in the school.
Thank you, counsel.
Thank you.
We don't have rebuttal here. You can do a post-argument submission if you wish. Thank you. Case 321 is Gallo versus Otten. We could probably do, 321.1. We can argue it at the same time, back to back if you wish, same lawyers. Good morning. We'll call 321 first. Mr. Potenza.
Good morning, Your Honors. Chris Potenza, Hurwitz and Fine, on behalf of, let's see if I can get this right, 252-8388 Ontario LTD, Ralph Betts and Amy Betts.
Very well done.
I think this is a pretty straightforward issue. It's an issue of duty. My client was operating a pilot vehicle. It's basically a pickup truck with a high pole, and he's escorting a oversized load traveling from Canada. Due to the height of various overpasses on the thruway, it has to snake through the city of Buffalo and eventually hits the 219 and heads south to South Carolina.
We understand the facts, and then
Yeah.
the truck hit the light on Minnesota and Maine, and then your argument seems to be that there's a contractual duty with the other party, not to the plaintiff, and they didn't launch any instruments of harm under Espinal, and therefore they're not.
That is correct. We're not responsible for planning the route, surveying the route. There was another company that was hired to actually test the route, within 30 days beforehand with a high pole, make sure there's no overpasses. That company has got out on the same argument, this duty argument that we've raised in this motion. So the issue is, we're coming down Main Street. Our high pole hits the light in the right-hand lane.
Wasn't the high pole a couple inches higher than what was recommended or approved?
It's a couple inches higher than the minimum standard that is put in the
So was it
escort
geared then,
manual.
to hit the light or hit the wire?
I'm sorry?
Was it then geared to hit the wire then, by being a little higher?
Well, we don't know, because we don't know the height. We'll never know the height of the light that was hit by the high pole, because it fell. The whole string fell. So we never know that height. He's an experienced escort driver. He testifies that he puts it above the minimum to account for any fluctuations in the road grade or bouncing or anything like that. So he identifies that the traffic light in the right-hand lane could be a hazard to the oversized load, which is only oversized by height, not width. He radios back and says, you got to negotiate between the two lights. The guy overcorrects, goes all the way into the left-hand lane, and hits the light and knocks it over. So our position is, we didn't do anything wrong. We identified an overhead hazard. We instructed the driver of the oversized load how to maneuver around it. He did not effectively negotiate that, and he hits the light in the left-hand lane.
But Judge Montour raised a question that I had the same question, I thought the allegations against Betts, against your client, was that the pole was too high, so it was unnecessarily high. So that the mere fact that it touched, it hit it came into contact there doesn't mean that the truck following needed to get out of that right lane. Do I have the facts?
I mean, that's a fairly speculative argument, Your Honor, because we don't know what the height of that light was, if his pole was 3 inches
Wasn't
lower.
tested though? I mean, isn't there a company that goes through and does the test? They go through the route with the pole on top.
It's not contemporaneous, it only has to be done. These are lights hanging on a wire.
Yeah, I
and
understand.
that has
I know
to
where
be
Maine,
done-
Minnesota is,
that
like we
ha-
do.
Yeah, that has to be done within 30 days of the route. So we don't know if there's any fluctuation in the height of those.
It was done a week
things.
before, the pilot run was run a week before, right?
Correct.
But why, maybe I misunderstand the facts, so forgive me, but why would your client not have the same height pole as the truck? I could see going an inch or two, but having it too high really doesn't give you any valid information. If you're the test vehicle, like your client was, and his pole is really high, higher than the truck that's following him, and it hits an object, that doesn't give a lot of guidance to the truck behind.
We're talking about 3 inches, Your Honor, and we're talking about going through city streets filled with potholes. There's going to be, he's an experienced,
Yeah, but once it hits, he tells it, and arguably, according to the test that was done before, it wasn't necessary to move from the right lane. But once it hits, he feels as though I got to move right from the right lane, move over to the left lane, and that's where the accident's
We'll
caused.
never know, we'll never know whether it would have hit, whether it was 3 inches lower or not.
Well,
We'll never know. That's
the test
speculation.
vehicle didn't, I mean, the one that did the test route did not.
That was
They
a week before, and this is on a guide wire. These things say.
I understand. I know what it is.
The main point is that he gives him a safe alternative. He says, go through the two lights.
Well, the safe
There's room
alternative
between
wasn't,
the two
that
lights.
lane wasn't tested at all. The right lane was tested. You're supposed to stay in the right lane.
I understand that. He identified a hazard. He advises him to move in between the two lights. The driver does not move in between the two lights. The driver moves all the way over into the left lane and strikes the light. That driver is responsible for the movement of his load. He's the only one who can control
Well, he wouldn't
that
have moved
tractor
otherwise,
trailer.
except for the directions from the pilot.
Excuse me?
He wouldn't have moved otherwise, except for the directions
Well,
from
the
the
interesting
pilot.
twist is he says he never got a direction from the pilot car.
But your argument is regardless of whether it's communication or whatever, he was wrong, there's no duty here, it's a contractual duty with the other party he contracted with.
Correct.
This is not Espinal, it doesn't fit into any of the three exceptions under Espinal.
Correct.
So you should win regardless of the facts, whether he was at fault or not.
That's correct, Your Honor. There's nothing that he did that made the situation more dangerous. You know, he advises this driver to avoid what he perceived as a low overhead light, move to the left around it, avoiding both lights, and the driver just does not negotiate that. And that's the basis of our argument.
Thank you. We'll hear from Mr. Mescal next.
Good morning.
I'm sorry to interrupt.
Sure.
It might make sense if I go next because Mr. Mescal
Okay.
is going to be responding to both of our.
Sure, he was next on the calendar, but that's fine. You go.
I mean, I don't want
You have any opposition to that?
I'd prefer to go now, Judge, if
All
I
right,
can.
you're second on the calendar, you go.
Okay, thank you very much. Justice Anna, congratulations. Thank you. May it please the court, Judge Montori, I think you hit the nail on the head. There was a scout vehicle that went out approximately a week before. Its purpose is to make sure that a load at the height of this truck, which was 15 foot 8 inches, could proceed safely. The regulations require that the height pole is set 3 inches above that, and that's exactly what the scout vehicle did, and the scout vehicle confirmed that this load would have fit through the right lane. By putting the height pole at 6 inches rather than 3, Mr. Betts doesn't make the situation more safe. He creates a dangerous condition. In any event, he testified that with his height pole, Mr. Betts himself estimated that the height of the signal in the lane he went through, the right lane, was approximately 16 feet. He nevertheless directed the driver of the truck, both visually and verbally, to move from outside that right lane. There is no proof in the record, and there's no reason to believe that that truck could have fit between the two traffic signals. We know it could have proceeded safely in the right-hand lane. We know that the truck moved after getting the verbal and visual direction, and I think that constitutes a significant question of fact as to the liability of Mr. Betts. There was a second point in the appeal, which wasn't verbally argued, but Your Honor, I also think that there is liability in the Betts defendants for their failure to comply with both the statutes and the regulations. That provides at least some evidence of their negligence. And for that reason, I think that the motion for summary judgment brought on behalf of the Betts defendants was properly denied.
Thank you.
Thank you.
Mr. Hendricks?
Thank you, Your Honors. Justin Hendricks on behalf of the defendant, respondent, appellants, Otten, Veldesgraaf, and Admiral Merchants Motor Freight. I would, in this specific instance, echo the comments by Mr. Mescal. Certainly think that the setting of the height pole is the question of fact that needs to be resolved with respect to whether or not Espinal could apply in this case to the Betts defendants. Certainly happy to answer any questions on that point.
Thank you. Why don't we move on to 321.1, and you're up on that appeal.
Thank you, Your Honor. Regarding that appeal, and here's Mr. Mescal and I no longer align. I think first that there is, at a minimum, an unresolved question of fact as to whether or not my client, Mr. Otten, it was a substantial factor for the happening of this accident.
And you say in your brief, you go a little bit further and say there's no evidence his truck actually hit the light. I mean, that seems, these things just don't fall out of the sky for no reason.
Certainly not, but from the testimony that was given, no one actually saw it fall. My client's testimony is my client's testimony. So.
Okay, but you want to move on to the next issue, that assuming that it was his truck and it just didn't fall out of the sky for no apparent reason, it wasn't a substantial factor in the plaintiff's injuries. The light, as I understood, fell onto his motor vehicle on the windshield.
And the argument on that point being that there's a proximate cause question in not whether or not the light was the cause of the damage to the plaintiff's vehicle, but whether or not it was Mr. Otten's actions that are the proximate cause of the light falling.
Well, a proximate cause.
A
right?
proximate cause.
Because you seem to focus, yeah, there's all these other things that caused it, but as you know, we say there can be more than one proximate cause.
And there certainly can, and I think that that is, again, at a minimum, the jury should get the opportunity to hear all of the facts from all the witnesses and apportion fault accordingly, which dovetails directly into my next point, which is that the plaintiff should be on the jury charge sheet as to whether or not their actions were a proximate cause to this accident.
The plaintiff's driving behind the truck at a slow rate of speed. And what did he do that he shouldn't have done? How was he negligent? Should he just pulled over to the side of the road? I mean, he has no idea the truck's going to hit this light.
Well, and that's precisely the point, Your Honor. You've articulated the exact problem. He has no idea if the truck's going to hit this light because he's so close to the back of the
So
truck.
anytime I'm following a truck through any intersection with a light, I should just pull over and let's see, make sure that guy gets through, you know.
It's certainly not so extreme as to have to pull over. I think a fair analogy could be made to this department's jurisprudence when it comes to snow and ice cases on the road. You have to be sufficiently far back to stop in those cases. I think similarly here, you have to be sufficiently far back to see the light and to know what this large oversized load is going to be able to do in front of it. And if you're so close such that a large oversized load should hit a traffic light and it should swing down and hit your car, you were following too closely.
Okay, thank you.
Your Honors, the proof in this case is that the truck moved from the confines of the right lane. It was taller than the traffic signal above the left lane, which the police measured at 15 foot 4 inches, that the oversized load struck the signal, dislodged it, and that it fell onto the truck of Mr. Gallo. There's proof in the record supporting those facts, Judge. As to alleged culpable conduct on the part of Mr. Gallo is driving on a city street. He's driving within the speed limit. He's got his seatbelt on. He testifies he stays far enough behind the oversized load that he can see both of the mirrors on the cab portion of the truck. First of all, there's no allegation in the defendant's bill of particulars that he was following too closely. But even if the court wants to consider that argument, there's just no proof to support it. And in fact, the proof is to the contrary, based on Mr. Gallo's own testimony as to how he operated his vehicle that morning.
Thank you. Case 322 is Guyette versus Clyda Health. 322. Good morning, Counselor.
Good morning. May it please the court, Marina Murray on behalf of the defendant, Dr. Mohammed Kulaylat. I would submit to this court that the plaintiff, in opposition to the defendant's motion for summary judgment, has failed to raise a triable issue of fact through the affirmation of Dr. Stevens, because there are two main issues with Dr. Stevens' affirmation. The first, and I would highlight as the most important, would be that Dr. Stevens raised a new theory of liability in opposition to the defendant's motions. Based on the bill of particulars, the complaint, even the discovery in this case, the deposition testimony, it was very clear that plaintiff's theory of liability was that there was a delay from the time that she presented to Buffalo General Hospital to the time that her appendectomy occurred, which was about 24 to 26 hours later. However, Dr. Stevens, in opposition to the defendant's motion, raises a new theory that, in fact, surgery should not have taken place. Plaintiff should have been administered IV antibiotics, observed, and that a possible precutaneous drainage should have occurred if necessary.
The plaintiff was given antibiotics shortly after entry, but so I understand your point. The way it was set up through discovery was you should have operated sooner.
Correct.
Taken out my appendix sooner.
Correct.
Following discovery, the plaintiff's expert said you did it too soon.
Precisely.
Or you shouldn't have never done it at all. It does seem like a radical change there. The bill of particulars, though, just has these general allegations of failure to diagnose and treat. Very general. they don't ever say more specifically what the theory is. So I guess the other side could argue, Dr. Stevens, his theory here, you should not operate it at all, is failure to diagnose and treat properly.
I would submit that there is one specific theory in the Bill of Particulars that I believe, at least for Dr. Kulilat's Bill of Particulars, is letter A, and that is the allegation regarding the delay in surgery, the delay in treatment. All the other allegations in the Bill of Particulars, I would submit are boilerplate allegations, which, if you look at the case law, are insufficient to put the defendant on notice of a specific theory. Particularly in this case, there's nothing in the Bill of Particulars, in the complaint, in deposition testimony regarding, intravenous antibiotics, observation, percutaneous drainage, nothing. It's particularly with the deposition testimony. There's no mention of those things whatsoever. And I think Justice Lindley raised a good point going into the second issue with Dr. Stevens' affirmation, is that it's putting aside the issue related to a new theory of liability. It's speculative, it's conclusory, and it's lacking an evidentiary foundation, because Dr. Stevens says the plaintiff should have been given antibiotics and observed, and that's exactly what happened. The plaintiff was given antibiotics on 2 different occasions over the course of about 24 hours, observed, and then taken in for surgery. Dr. Stevens doesn't put any kind of time period on how long the plaintiff should have been observed before surgery, or how long she should have been administered antibiotics.
Sounds like he takes a position that surgery might not have been necessary at all.
Dr. Stevens...
That the antibiotics might have cleared everything up and she would have been totally fine. It looked like Judge Licata's answer to this was, Stevens talks about possible drainage as needed. The way that Judge Licata says, that's not really inconsistent because that's surgery. He likens it, he says, and it requires an incision and qualifies as a surgical procedure. So that seems to be his resolution of the change in theory argument. Do you read it that way too?
I respectfully would disagree with that interpretation. I think that if you look at Dr. Stevens' affirmation, he himself labels this drainage as non-operative management. So I think it's very clear that Dr. Stevens is not putting the IV antibiotics and the drainage as a surgical...
He says it's not surgery.
Correct,
Yeah.
correct. So for that reason, I would disagree with Judge Licata's reasoning in the denial of our motion for summary judgment. Unless there are any other questions, Your Honor, I will rest on my papers. Thank you.
May it please the Court, Melissa Zittel from Gibson, McCaskill, and Crosby for the defendants Kaleida Health and Buffalo General Hospital. We would join in the arguments by Dr. Kulilat on both counts, and also note that the Bill of Particulars does, on the record at page 370, the plaintiff amended the Bill of Particulars at the close of discovery, and the record at page 370 indicates that there is a specific claim for delay. In fact, it's the Bill of Particulars, the amended Bill of Particulars states, the delay in timely diagnosis and proper treatment worsened the condition for which she presented. So that is specifically stated as the claim as of the 2 months before the note of issue was filed. In addition to that, we join in the same argument that in addition to it being a new theory, there's no foundation for it because the plaintiff was in fact given antibiotics for a 24-hour period and monitored under observation. So the treatment that their expert is saying should have been done was actually done. I don't think that this court will have to address the issue of vicarious liability based on the arguments already before the court, because if Dr. Kulilat is granted summary judgment, if the lower court's decision is reversed, the hospital would not be vicariously liable for him by operation of law. However, if for any reason the vicarious liability issue is addressed by this court, Dr. Kulilat was not an employee of the hospital, and the case law is clear that the hospital is not responsible for physicians who are not employed, and Dr. Kulilat was an independent contractor. He was a surgeon who was affiliated with a private group, and that's part of his deposition testimony. He was part of the University of Buffalo Surgeons practice. The court below relied on Maduba. Obviously, Maduba is a case that involves emergency medicine. This is not an emergency medicine.
The plaintiff here
case.
came in specifically to see Dr. Cooler.
And there was a 24-hour period, so it was not, the surgery was not done on an emergent basis. She was given antibiotics for a period of 24 hours and observed first. Additionally, unlike the facts in Maduba, there's a unique fact here where the plaintiff herself was an employee of Buffalo General Hospital for a period of 30 years, so may have had actual knowledge as to the relationships that exist within the hospital where she worked for 30 years. Additionally, there's no issue of fact, similar to this court's decision in PASIC, there's no issue of fact raised on ostensible agency. None of those three factors have been addressed by the plaintiff in any format. Finally, another issue that I don't think this court will have to reach, but in the off chance that it does, the court below found, we would argue incorrectly, that Kaleida Health was vicariously liable for Dr. Kulilat as a matter of law. This court held in the Facklem case that that's an issue of fact for the jury and shouldn't have been decided as a matter of law.
Thank you very much.
May it please the court, I'm Joy Miserandino representing the respondents in this matter. I would like to start, given the questioning before, with stating that the main issue that was raised by the appellants in their arguments is that this is a new theory in the Bill of Particulars, which is really two issues: what was pled in our Bill of Particulars, and what are the parameters of what needs to be pled in a Bill of Particulars. And if I point to 460 of the record, which is RBP for Kuliat, 3A specifically says, and this follows Dr. Stevens' expert affidavit exactly, failed to properly and timely treat, diagnosis, and perform a surgical procedure. And let me interject that if anybody gets a pacemaker, that's a surgical procedure. Surgery is not defined as, there's actually surgical procedures, there's surgery, but they all come under the veil of having any kind of intervention with the body. So a pacemaker is a surgical procedure. Inserting a drainage tube is a surgical procedure. Failed to properly, timely treat and diagnose and perform a surgical procedure on behalf of the plaintiff who presented with appendicitis. The delay in diagnosis and surgical procedure resulted in a more extensive surgery, causing her condition to worsen and an extended time of hospitalization, disability, and scarring. I don't know, just as we're charged with knowing the law, doctors are charged with knowing the different diagnoses and a different treatment that needs to take place. So Dr. Stevens, a Harvard-educated medical doctor, this outlines exactly in 3A what he's saying in his expert affidavit, and that was in 2018.
Would you agree with this much, that the plaintiff's deposition, she worked at Rochester General, but she's not an expert or anything, but would you agree that her deposition, the theory of liability that she articulated there was, they waited too long. I'm in there in the hospital, I'm waiting, nobody can figure out why you're taking me so long to remove this, to do the surgery. That was the theory as she articulated during her testimony. I'm not saying that you're bound by that, but would you agree with that?
Well, I don't know if she knew what they were even supposed to do. She was a radiologist. That might be that you're supposed to put me on a stage. And can I stress, stage doesn't mean 24 hours. Surgeons like to do surgery. Surgeons cut. That's where they make the most money.
But she wanted it out. She wanted her appendix out
It's
soon,
a
and
lay
she was
person.
upset about the delay.
Right, but if
why are
he
you
had-
taking so long? Can we just get this done already? But again, I'm not saying you're bound by that, but that was her theory of what went wrong.
her theory as a layperson who's
Yes.
laying there in pain. Now,
Right.
if Dr. Stevenson walked in and said, you might want it out, but listen, we might be able to avoid that altogether. Let's put you on stage antibiotics. Let's insert in a surgical procedure a tube that would drain it, and maybe you won't need it at all.
Doesn't he say, though, that the drainage is not surgery?
I don't think he
Dr.
ever says
Stevens?
in his, that it's not surgery. I don't think there's a doctor who wouldn't say that inserting a tube, inserting a pacemaker isn't a surgical procedure.
I thought I saw that, but I could be wrong.
And I would also say that it not only falls into what is in our bill of particulars, which I think in both our bill of particulars and our amended bill of particulars, we clearly state it wasn't diagnosed properly, it wasn't treated properly, and the procedure that, and the surgical procedures that followed were not proper, nor, and he said right in 2018, it required a more extensive surgery. That has always been the theory. And even the law is that the bill of particulars do not have to be evidentiary. They don't have to be expert. Medical malpractice is a unique form of tort. And often things, it develops slowly over the course. I think the bill of particulars here were more specific than they even needed to be. Judge Licata, this argument went on for over an hour. In a 7-page decision, which I practiced before the state court many years, and I have never or rarely gotten a decision that detailed, stressed that the purpose of the bill of particulars, and now the practice with the defense bar is to have you particularize it so much more than is necessary, which is why there's a flood of that litigation before the court of this bringing motions that they're demanding things they shouldn't. In fact, many of, I think, the defense cases in this support us.
What do you say? Counsel this morning said that there was an amended bill of particulars that was served that delineated, specified the delay theory.
I have that, portions of that amended bill of particulars right here, Judge, and when you say they failed to properly, adequately, and timely diagnose the condition from which he was suffering, if he had diagnosed that it was a complicated subacute versus a complicated acute, then he would have followed the right treatment. Which he should have known. I think surgeons rush to surgery. We also say failed to provide the plaintiff with proper and adequate surgical services.
Counsel, I'm sorry to interrupt you here, but is it your understanding then if in a bill of particulars it says that the provider failed to treat, diagnose, and perform take the appropriate steps, that's sufficient in a bill of particulars?
No, but ours went beyond that.
Yeah, but you didn't say, there's nothing in the bill of particulars that said the appropriate antibiotics weren't delivered, and the antibiotics weren't timely delivered, and that the patient wasn't observed during the period of the delivery of antibiotics.
Judge DeConte, I would say that, and I would agree with Judge Licata, that our bill of particulars fall within, and I think even more so, which is required at that time.
But
I
just
don't
to
think
be
you're
clear,
required to say I think that's expert disclosure.
But just to be clear, as I understand, the drainage tube is ancillary to the battery of antibiotics. It's the antibiotics that are under your, Dr. Stevens' theory, is the treatment.
The staged antibiotics
Right,
over a period of time.
But the treatment plan that you believe that should have been given to your client is not, the failure to provide that particular treatment plan isn't here.
The particulars of the treatment plan isn't, and I don't think they're required by the applicable law. I think that our bill of particulars falls within what is required. I would also like to point out that she did not present to see that doctor specifically. She didn't know him in all the years that she worked there. She presented to an emergency room. And I think the Judge Licata was absolutely correct in that aspect of his decision. And lastly, this is, as the court knows, a motion for summary judgment. It looks like a very clear battle of the expert cases, and it's issue finding, not determination.
Thank you very much, Counsel.
Thank you.
Appreciate it. right, the next case for argument is 325 Nushan W. versus State of New York, 325. The appellant has submitted, and we have respondent appearing virtually. Mr. Hitsos, good morning. You may proceed.
Good morning, Your Honors.
You're submitted.
For the state, I understand that the appellant has submitted, so the state is here to address any questions and concerns that this court may have.
I don't have any questions on the merits, but procedurally, it looks like the appellant, he appealed from a decision. The notice of appeal says he appeals from a memorandum decision. There's a subsequent order. I don't know if you looked into that, whether, because of course no appeal lies from a decision. Have you looked at that? Do you have any views or positions on whether this appeal is even properly before us?
We understand him as appealing from the denominated order. There was an underlying decision and there was also an order in the case, and we regard the appeal as being from the order. We understand that there is no appeal from a decision, but...
You recognize the notice of appeal references the decision only, not the order, but you sound like you have no objection if we just treat it like he appealed from the right paper.
Correct, Your Honor.
Okay. Anything further?
No, Your Honor. We're here to address concerns from this court.
Hearing none, thank you.
Thank you.
Case number 326 is Cosgrove versus Zinno, 326.
Good morning, Judge.
Mr. Cosgrove, good morning. Mr. Roach is here virtually.
There's no facts in dispute here.
True.
And the only question is your familiarity with the fee dispute program and the statute of limitations. And I'm suggesting here that I'm entitled to know whether or not my complaint is in order, and that I can go forward and prove before a judge or a jury that I'm entitled to my fees. Unless you have any other concerns, I'll leave and wish you well.
Thank you. Mr. Roach, do you wish to be heard?
Yes, Your Honor. Thank you. May it please the court. We believe that the decision and order of the court below is absolutely clear and completely consistent with Filemeyer, which we understand to be applicable law. Bottom line is that Title 22, Part 137, which was promulgated by the Chief Administrative Judge of Courts, mandates that attorneys participate in arbitration of disputed fees. The exception cited by the appellant, that is that services were not rendered at least 2 years or more prior to the dispute, is an absolute bootstrap, rejected by the court below, rejected by Filemeyer. And if attorneys who are required by 137.11 to participate in arbitration of disputed fees can simply avoid that by delaying the sending of a bill, then 137.11, 137 itself really has no meaning. If the court has any questions, I certainly can answer. If not, I rest on the arguments in our brief.
Thank you, Mr. Roach. Next case for argument is 327 Clark versus Cusinata. Mr. Lamb, good morning.
May it please the court, if I may, just a personal note. There's one justice sitting all the way to the left. I've been up here several times and I've missed seeing him, and that's the Honorable Scott Del Conte. And it's nice to see Justice Del Conte here. I am going to tell the court that this is my swan song. I've been coming up here for 50 years. My first justice was 50 years ago. As a matter of fact, the Honorable John Marsh. It's a long time. And maybe I've learned something over the 50 years. Today, unless the court has some questions, I'm going to rely on my papers, on my brief and my reply brief, because I think it said it all. And
I don't have any questions for you, but I have a few comments. I want to congratulate you on a distinguished career.
Thank you.
Long career, great service. I'm told one of the leading trial lawyers in the state for this particular area of law. We've seen you here before and know the quality of your work. Of course, it has no bearing on the outcome of this case.
No guarantees.
The facts and the law carry the day here, but we do want to recognize your career, the amazing work that you've done, and want to wish you the best of luck in whatever you're doing next.
Thank you, Your Honor. Appreciate it.
All right. Ms. Klusick?
Good morning, Your Honors. May it please the Court. I'm here on behalf of Dr. Kandel. As Mr. Lam said, I think that the arguments were all very thoroughly made in the briefs. I'm going to refer the Court to those arguments. It's our position that the Supreme Court made a narrow and appropriate ruling based on the allegations that the plaintiffs had made in the complaint in the Bill of Particulars, and that in the context of this motion in limine prior to trial, that the order should be affirmed.
All right, thank you.
Morning, Your Honors. May it please the Court. Andrew Borelli on behalf of the Kraus defendants. As I'm sure the Court's aware from my papers, my clients are in the case only vicariously for Dr. Kandel. And in light of Dr. Kandel's attorney's argument, I'd also rest on my brief unless the Court has any questions for me.
No questions, thank you. Mr. Lamb, good luck.
Thank you.
Case 329 is Olivia Lester versus FD Capital LLC. We are waiting for Mr. Cartwright to appear virtually, and then you may commence. Is Mr. Cartwright in the waiting room? The virtual waiting room?
Judge, we're trying to get him to come in.
Okay, thank you. Please bear with us just a moment if you could. All right, he is with us, so Mr. Volz.
Thank you and good afternoon. May it please the Court, Robert Volz on behalf of the plaintiff appellant, Olivia Lester. Olivia Lester fell and broke her ankle when she tripped on the lip of the door of the house that her mother was renting from FD Capitals, the respondents here. The lip or the threshold of the door was 10 inches high. That's a violation by 2 inches of the New York State building codes. We're here because the trial court found that Ms. Lester did not trip on the out-of-code threshold, but that the door closing caused her to fall.
Yeah, I think the confusion is, at her deposition testimony, she said that she tripped on the lip of the door, quote, and then there was some testimony her foot may have been stuck in the door. I think your position is she was describing not the actual door itself, but the threshold?
That's correct.
But you don't dispute that, because she did testify later. After her foot, she fell before her foot got caught in the door, which is the second issue. So it sounds like
That's correct. There were two
Your position
things.
is she tripped on the lip that was too high, fell, and then the door closed on her. But the door isn't what closing on her is not caused her to fall. That's your reading of it?
That's correct, Your Honor. There were two things that happened to Ms. Lester at the time. She tripped on the height of the threshold as she was entering, and the door closed on her. The record's pretty clear. When she said, "I tripped on the lip of the door," defense counsel then pulled up a photograph. It's at 181 of the record. He pulled up a photograph and said, "Can you show us what you mean by the lip of the door?" And she actually marked an X on the threshold. She didn't mark an X on the door. It was pretty clear, I think, in reading the record that defense counsel knew it was the height differential that caused her to trip. She said on 2 subsequent occasions when asked, "And then what happened?" the door closed. And one of these occasions, it was a matter of a multiple back and forths on page 78 and 79 of the transcript. On one of those occasions, she said, "As I was going down, the door closed on my foot. I was down on the ground," and it's not really clear whether she was already on the ground or on her way to the ground when the door closed. But it's clear that she tripped when her foot hit the thing that's marked with an X at page 181 in the record. And then the door closed on her foot.
What type of notice did the defendants have with respect to this? Didn't they just buy the house
Yes.
before?
Yes, Your Honor. And in fact, that takes us to our next point. That door can be seen from the street. You can walk up and look at that door, and you can measure the height. And you can measure that it's 10 inches high instead of the normal almost 8 inches. As far as the notice, FD Capital purchased that house on March 2nd, 2020, 4 months prior to this accident. They said we inspected the exterior of the house before purchasing it. Then, in June, when they renewed the lease with Ms. Lester's mother, they also did a full inspection inside and outside. Now, can I prove that he actually measured the height of that door when he, the principal for FD Capital, who it's his job to rent homes and remediate them, can I prove that he actually measured the height of that door? No. But we can prove that he inspected that house on 2 occasions. Now, is that actual notice of the 10 inches of the height? Or is it constructive notice? At the very least, it's constructive notice that that height of the door was 10 inches. It's constructive notice that that door was in violation of the New York State Building Code, period, end of story. The reason we're here is because the trial court accepted the defense in this case while acknowledging that the plaintiff's claim was that the threshold was too high. And still, she made a finding of fact and said, "I think that the door closing is what caused her to fall," despite the contrary submissions by our firm, despite the contrary facts in the record. She made a finding of fact. In determining summary judgment, it's issue finding, not fact finding that needs to be.
Whether she tripped on the landing or got her foot caught in the door as it closed, you're not saying you should win as a matter of law on that. You're saying that should be for the trier of fact. It goes to trial. And she can explain it, and there can be better questioning on that. There wasn't a lot of follow-up here on that.
Well, and that's correct, Your Honor. Look, a premises that's out of code is some evidence of negligence. Am I going to win on summary judgment? No, that's why we didn't cross-move. Because we understand that there's a question of fact for a jury to determine. And actually, the moving papers really just addressed notice. And so we had our expert show, yeah, this is 10 inches and that's out of code. And We also then followed it up with, and he inspected twice. He should have been able to figure this out. So we have constructive notice.
Is it mutually exclusive that, let's say that her foot did get caught in the door? Does it necessarily follow that the cause was not the riser being, the landing being too high? It may
No.
have, well, contributed to the reason she caught her foot in the door, it was too high.
Well, and it is not, Your Honor, I agree. Also, it's not, wouldn't have been unreasonable if our expert had said that door that closed too quickly, and our client said it once, yeah, that door closed really fast. It wouldn't be unreasonable to say there were two negligent conditions there, but my expert said, look, it was the height that caused her to trip. And so we're going with our expert's opinion to us at this point.
Thank you very much. Mr. Cartwright is weighing, I can just tell he's, can't wait to get involved here.
Good afternoon, Your Honors, and may it please the court. Before I start, congratulations, Judge Hanna. Your Honors, I represent the defendant respondent in this matter, FD Capital. I want to orient the court to a couple of background contextual facts just with regards to this premises liability action. So, as Your Honors are aware, FD Capital comes into possession of this property a couple of months before this incident occurs. It didn't build the property. It didn't make any renovations to the property. It would have bought it as is, and it would have continued to rent to the same tenant, which is plaintiff's mother, that had rented the place for about 15 years prior. She continued in with living at this premises. She had never had any prior complaints regarding this side door. She had used it many times, never had any prior complaints, never had any prior slips or trips or falls or any issue whatsoever with this side door or threshold. That, I believe, eliminates any issue with actual notice. Not only that, but the plaintiff below did not put in any opposition regarding actual notice with respect to the paper. So as we indicated in our brief, I believe that issue is effectively conclusively abandoned. But just going a little bit further with respect to the background facts. Your Honors, this is a case where, you can tell that as the testimony progresses, we learn about the true nature of what plaintiff is claiming. And we tried to present that to Your Honors by actually dropping in the screenshot of the deposition testimony that shows that Ms. Lester, the plaintiff, she first testifies that she falls on the lip of the door. And unsure of what that meant, the questioning attorney, David Walsh, asked, what do you mean by that? Is it the door or is it the threshold? And she kept saying the lip of the door caught on my foot. As to whether there's any, further follow-up or development of that point, I think the questioner was pretty satisfied at that point, given the three separate screenshots of testimony that we put into our brief on pages 5 and 6, that it was pretty clearly the door that caught her foot, causing her to trip, not the threshold.
How do you deal with the X on page 181? She was asked, where did you fall? And the X, I can't even see a door in that exhibit. The X is on the landing there. What do you say to that?
That is exactly my answer, Your Honor. The door is not pictured in there, and that's sort of the progression of the questioning, is that she's asked to identify where she fell. She puts the X on it, and then she continues to describe that the lip of the door caught her foot as the door shut, which, read in context, if it was in a vacuum and it was just lip of the door, I might understand plaintiff counsel's argument about maybe it's the threshold, but it's the lip of the door that closed on her foot that leads any reasonable inference of what happened to mean it was the door, not the threshold. Now,
how do you deal with page 79, where question is asked, were you already on the floor when that happened, meaning you caught your foot on the door? She says, quote, I was going down when it closed on me, yes. Counsel seems to suggest that she was falling due to something else, and then the door caught on her foot in that order. What do you say to that?
And I would just point out that again, with the rest of her deposition testimony, as she's describing it, it's that she's going down as a result of the door catching on her foot, and that it closes on her foot, as you point out in page 79. So she trips on it because it closes, and then it shuts on her as she's going down, as I read the testimony.
Yeah, I will say this, it's a little unclear. I had to read it. When I first read it, I'm like, yeah, she did trip on the door, not the landing. But then you get more into it and it's a little unclear, and I guess somebody could look at it and say, well, because it's not conclusive, let's send it to trial and this could be explored. What would be wrong with that approach?
Well, the reason that the court below affirmed is because it found that there was sufficient evidence that if you were to give this its most reasonable and even its most liberal interpretation, it's clear that the cause of the fall was the door. But I think you're asking the question of, if you were to even set that aside and say, maybe it wasn't, maybe it was the threshold. The other arguments that I would simply put forth is there is certainly no actual notice. For reasons I put forth before. There was no constructive notice because there was no reason, based on those tenants' lack of complaints, lack of any request to fix it, lack of the time of ownership that FD Capital had of this premises, to indicate that it knew or should have known that there was any sort of violation. There's certainly nothing in the record to suggest that there was a prior violation found or that there are any changes made to the side door. So based on that, there's a lack of any sort of notice, actual or constructive, and FD Capital certainly didn't create it. So there's certainly no notice or creation of any defective or dangerous condition. So irrespective of whether it was the door or the threshold, again, we believe it's pretty clear it's the door, and that's our proximate cause argument. But even if you were to set that aside and say it could have possibly been the threshold, the evidence also establishes prima facie, and plaintiff has failed to raise any issue of tribal fact as to whether there existed any sort of notice or creation of defect. So that's our alternative argument. The last thing I would point out, Your Honors, and we pointed it out in our appeals, is that in the motion papers below, we did put in our statement of undisputed material facts. The plaintiff didn't oppose them. They become the law of the case. I do know that subsequent to this motion coming out, there was some discretion about whether some courts required it or not. We put it in because Monroe County Supreme required it at that time, and plaintiff's failure to oppose it makes those facts the law of the case. With that, Your Honors, I would rest on my papers. I would respectfully request that you affirm the trial court's determination and find that summary judgment is appropriate in this case.
Thank you.
Thank you.
Case 330 is Dreamco Development Corporation versus Cranesville Block Company Incorporated, 330.
May it please the court. John Manier from
Actually, hold on 1 minute.
Oh, I'm sorry.
We are waiting for Mr. Marthy, and there he is. You may proceed.
Thank you, Your Honors. May it please the court. John Manier from Ralph Larigo's office. I'm here on behalf of Dreamco Development Corporation. Before Your Honors is an appeal from the denial of Dreamco's summary judgment motion on its breach of contract claim. What we have here is Dreamco, who has decades of experience in selling, installing, and mixing concrete for commercial and residential projects. They are an expert in the industry, and they have thousands of contacts in the Erie County area and surrounding areas. At issue before this court is a contract. It is a straight services agreement. It's a one-page document. It's very clear. It's unambiguous. There's essentially three terms. Well, the length of the contract is about 19 months. June 1st, 2019 through December 31st, 2020. And then there's three terms. The three terms all encompass services. The first term, very important to Cranesville, is that Dreamco and any of its affiliates could not compete with Cranesville. That's important because Dreamco had such a groundwork here in the Erie County and surrounding areas. They had many contacts. Cranesville did not want that competition.
So meaning Dreamco couldn't sell anyone else's concrete for that 19-month period?
Couldn't sell it or compete.
Right. And then they were supposed to sell, they were getting $7,500 a month, and they were supposed to, on an annual basis, sell 40,000 cubic yards of cement over the 19 months, more than that, of course. But so really, it seems to come down to the issue of whether the UCC will apply here, 2-609, because, and that turns on whether it's a sale of goods or is it a contract for services. Your position is that this is just services.
That's exactly correct.
And therefore, because it comes down to the issue of, could they demand reasonable assurances that you were going to comply? Because it didn't look good. It
Well-
did not look good. You had like 11% in January, and you had a lot more to sell. They were understandably a little worried, but, so it was reasonable for them to ask for assurances, but if it's not a UCC case, you don't have to give them any assurances.
Exactly, and we had 12 months to complete that 40,000 cubic yards of concrete sales. And it wasn't us selling, it wasn't Dreamco selling, we were procuring purchasers for Cranesville. So the nature of the contract was Dreamco's ability and contacts, client lists, to obtain purchasers with Cranesville to purchase Cranesville concrete. And that's set forth in all of the concrete receipts in the record. We are not a party, Dreamco is not a party to any of those receipts.
Can I ask you a question? Did plaintiff ever take possession of the concrete before it reached the end consumer?
No, and that's exactly, you're right, Your Honor. You're hitting on the exact point of why this is a services contract. Not only did we not take possession, we were not a party to any of those sales agreements from Cranesville to prospective purchaser.
Is there evidence of that in the record? Because I agree, Judge Ogden's question goes to the heart of it. And if the concrete went from Cranesville to Dreamco, and it's in their facility, and then you sell it to somebody else, that might be a little bit different. But you're saying the way it was structured here is Dreamco finds the clients to buy Cranesville concrete, and then Cranesville has it delivered to those purchasers directly. So Dreamsville's hands are not on any of that concrete. That's what you're saying, right?
Yeah, I am saying that, and that's set forth, if Your Honors look at the amended complaint. In the amended complaint, there's some allegations that one of the reasons that Dreamco was not, or sold only 11,000 cubic yards of concrete was because Cranesville failed to provide enough delivery people, delivery persons, delivery trucks, etc. That's set forth in the amended complaint, those allegations. So that goes to Your Honor's points and questions with regard to Dreamco having any ability in touching any of this concrete. It wasn't that.
If they did touch it, would it be a sale of goods? UCC applies. If it was delivered to your client?
I would still argue that it wouldn't be.
Still
simply
services?
because it would be some sort of a constructive possession, but our Dreamco's position in this, and the reason why this contract came about was because of its experience, contacts, and its foothold in the Erie County and surrounding areas.
They were
That's why they were
providing
hired.
services. The services were sales.
Services
They weren't
were-
buying any goods.
Correct, but services were access to not only their contacts, their marketing strategies, their credit information, and not compete. They had the ability to mix concrete and sell it in the area. Because if Your Honors, I'll point to the contract, it's page 83 of the record. It says not only Dreamco, but any of its affiliates, other corporations, related corporations or entities. In fact, Dreamco had one entity that was mixing concrete at the time of this at the time of the contract. So they certainly had the ability to sell, and they didn't. There's not an allegation that they breached the non-compete. There's not an allegation that they failed to provide client lists, credit information, or marketing strategies. And in fact, a very important point is 9 months into this contract, okay, that's February 1. That's when Cranesville stops paying. Now, February is important because the construction season, the spring is there. That's when everything heats up in terms of concrete sales. And Dreamco, one of the main reasons why Cranesville wanted them, they have the ability to sell 40,000 cubic yards of concrete in one day.
So
They
when
have
there
the
was,
contacts.
there was an email January 31st asking for assurances, doesn't look good, what do you got, what's your plans? What was the response to that?
Well, there was.
Now, it doesn't matter if UCC doesn't apply, you don't have to respond at all, but.
Sure.
The response was, look, we could find one customer to fulfill the 40 cubic yards, or 40,000. Was that what their response was? This isn't a problem?
That wasn't their response, but Cranesville's response was, or Cranesville's offer was, give us adequate assurances you're going to sell within the 3-month or May 31st deadline. And yet, not only did they didn't even give them a reasonable time, didn't give Dreamco a reasonable period of time to respond to that. The very next day, they stopped payment. We didn't even have the ability to respond to that one day, less than 24 hours later, and they stopped payment, breached the contract. Again, Dreamco was brought on, and this whole contract came about because of its foothold, its experience, thousands of clients, decades of experience in the concrete industry in the area.
Your client gave up the lost opportunity to deal with other suppliers that could have made.
Exactly, and this is, again, there are red herrings with Cranesville's brief with regard to failure to properly raise the issue in the lower court. It was raised. The lower court considered the UCC application below, and therefore it's properly before this court. Even if you look at the amended complaint, the Cranesville makes the argument that there's an admission or a statement therein that the UCC applies, that Dreamco said that the UCC applies. That's just not true. If you look at paragraphs 11 and paragraphs 24 of the amended complaint, it simply says Cranesville failed to complete or make their adequate assurances within such and such a timely period. It's just a hyper-technical allegation with regard to the UCC. There's never an admission that the UCC applies here. And in fact, pleadings are loosely construed because the intent is to plead in the alternative. Courts have allowed pleading in the alternative. Issues are fleshed out throughout the cases, and that's what we have here.
So it seems like on the pivotal issue of whether the UCC applies, whether it's a contract for goods or services, it's either, there's 3 options. One is to say the UCC does not apply, it was for services. Second one is to say it does apply, it was the sale of goods. There's yet a third option. There's some case law that is out there that talks about whether a contract is in essence one for services or one for sales of goods can be a question of fact. So the question may be, the third option is we need a little more clarity on evidence on the nature of the contract and this issue of was concrete supplied directly to your client. So there's a third option is maybe there's an issue of fact and it goes to trial on that.
So I would respond to Your Honor with regard to that issue. And it was raised earlier by Your Honors both with possession, if we took possession, if Dreamco had possession of it and delivered it. Well, again, in the verified amended complaint, which is verified by Dreamco, Cranesville failed to provide enough delivery men, delivery trucks to deliver the concrete to the procured purchasers in the Erie County area. And that's the verified allegation. So that
was not disputed?
It's not disputed before this court today. And again, we would ask that the court reverse the lower court's decision. We'd ask the court to grant Dreamco summary judgment on its claim.
Thank you.
Thank you, Your Honor.
Mr. Marthy, good morning to you.
Good morning, Your Honors. May it please the court. I represent defendant respondent Cranesville Block Company, Inc. on this appeal. And I want to start out with the issue of whether the UCC applies to this transaction. And the first point I want to make is that that issue is not preserved for appeal, or it shouldn't be preserved for appeal, because the issue was raised for the first time in Dreamco's reply papers on the underlying motion. And one thing is clear is that at the time that this action was commenced, both parties were of the understanding that the UCC applied to this transaction. There's 3 separate references in plaintiff's complaint to UCC section 2-609, which is a section on the demand for adequate assurance. And there's 2 other separate references to demand for adequate assurance by Cranesville. There's also a reference in Dreamco's reply to Cranesville's counterclaim, where they assert as an affirmative defense that Cranesville didn't comply with the requirements in UCC 2-609. But one thing is clear,
Counsel, can I ask you a question? Didn't plaintiff contend that the contract was for the sale of services and not the sale of goods? Didn't he, I'm asking you as it relates to preservation. Didn't he make that contention?
Did he make that contention in his motion papers?
Yes.
I think.
And below, and below. Wasn't that his claim?
In the motion papers below, well, he did make a reference to that in his client's affidavit and possibly in the attorney's affirmation, just a passing reference to that this is a contract for services. So I think there was a passing reference to that, but his motion papers were silent on whether the UCC applied to the transaction and also whether, 2-609, there's no mention of it whatsoever. And the plaintiff knew that this was going to be an issue in the case because they alleged in their own complaint, they presupposed that the UCC applied. It's clear from the allegations in their complaint referencing 2-609. They didn't deny that it applied.
Right, well, their argument would be, and you anticipate it in your brief, that they'll say, well, we were just replying to your reliance on it in your opposition papers. And you seem to be suggesting, well, they should anticipate all the arguments you're going to make and address them head on. They seem to take the position, well, we're going to wait and see what you say before we craft any further arguments.
Yeah, I mean, I did, one of the cases I cited in my brief was the Gulledge versus Jefferson County case. That's a third department case. And they addressed that issue of whether the moving party should have anticipated an argument in their moving papers and addressed it in their moving papers instead of addressing it in their reply. And the court in that case said, since there were references in the pleadings which should have made the movement aware that the other party, the opposing party, would be opposing the motion on that basis, he was obligated to have brought up those arguments in his motion papers. And since he was bringing it up in his reply papers for the first time, the issue was not preserved for appeal.
All right, with respect to the merits briefly, counsel asserted, I should say, that no concrete changed hands between the two contracting parties. Do you agree with that on a factual level?
I believe that's the case. I know that there were some transactions between Cranesville and a company that Ms. DePizio, who's the principal of Dreamco, actually has an interest in another company called Stratman Park LLC. And Stratman Park LLC purchased a quantity of concrete directly from Cranesville. But other than that, I'm not aware of any direct exchange of concrete between Cranesville and Dreamco. Dreamco was, selling the concrete for Cranesville.
So how is this different than, let's say that you have a car dealership and I'm selling cars for you, and you pay me a salary, what have you, monthly, $7,500 a month to sell cars. Would the UCC apply there? I'm not buying any cars from you. I'm just selling your cars to somebody else. Is our contract between you and me for services or for goods?
Yeah, I mean, in the scenario you just described, Your Honor, I don't believe the UCC would apply. I think what makes this case different is the fact that there's an annual sales quota of 40,000 cubic yards. It's not over 19 months, by the way, as counsel had mentioned. It's an annual sales quota for 40,000 cubic yards per year that Dreamco was required to sell on Cranesville's behalf. So I think that makes it a different situation. I think the heart of this contract was the fact that Dreamco had an obligation to sell a certain number of cubic yards per year for Cranesville.
They didn't violate, they didn't get a chance to violate that because they were terminated too early.
Yeah, in response to that, there's a couple of arguments. First of all, on February 1st is when we made the demand for adequate assurance, and the following day is when our next payment was due. And under the UCC 2-609, a party can suspend payment after making a demand for adequate assurance pending the receipt of the adequate assurance. So it had a right to suspend payment. The contract wasn't terminated until March 18th, which was some, 45 days later. At that point, Cranesville hadn't received any response to its demand for adequate assurance, so it terminated the contract, which, again, it had a right to do under 2-609, which says that if the other party doesn't respond to the demand for adequate assurance, they've repudiated the contract.
So the issue is cleared up, is teed up for us, is does the UCC apply to this contract? If it does, then your client had the right to ask for, to get some assurances. If not, then it doesn't look good for your client. So we'll have to take a look at that issue.
Your Honor, just one final point.
Sure.
I'd like to make, I did cite some cases that demonstrate, in essence, there's a common law basis for Cranesville suspending payments to Dreamco. And the two cases that I cited in the brief were the Sunshine Steak and Seafood case and the All Brand liquor discount case. And in those cases, the courts held that where it becomes clear that one party will not live up to a contract, the aggrieved party is relieved from the performance of futile acts or conditions precedent. And I think our situation fits within that category. So I think Cranesville also had a basis to suspend payment based on those cases.
Thank you very much.
Thank you.
Congratulations, Judge.
Our last case is number 331 is Van Hook versus Doak and others. Good morning. You may proceed.
Good morning, Your Honor. Your Honors, Neil Johnson from Egan and Heimer, and may it please the court. I'm appearing on behalf of Defendant Appellants, University Orthopedic Services, and Dr. Jeremy Doak. As you know from our papers, it's our position on this appeal that certain allegations against these defendants should have been dismissed on the lower court's order on our summary judgment motion. Our basis for this position is pretty simple, that any agreement made in court, or an open court, between counsel for the parties is binding and enforceable, and that in this particular case, counsel for the plaintiff agreed to withdraw the allegations that we've identified during argument on our motion. Now, after briefing on this appeal, it's become clear that the respondents, the plaintiffs, are in agreement with our position, at least with respect to certain allegations.
Counsel, can I stop you there for just 1 moment?
Of course.
To be clear, there's a distinction, at least in my mind, between allegations, factual allegations, and theories of recovery. So there may be certain allegations that are tied, multiple allegations tied to a particular theory. As I read your brief, there's 3 theories of recovery you believe were conceded to that should be removed from the action. Negligent nursing training and staffing, negligent neuromonitoring, and the failure to order consultations.
Generally speaking, I would agree that those
are the
theories were
three
conceded.
theories, and they're divided up into factual allegations within the bill of particulars that you say there was no response at below.
Yes, so our issue is that the court's order on the summary judgment motion doesn't actually reflect dismissal of, you could call the theories specifically or the allegations.
Right, but there's a difference. It wouldn't be appropriate to, in a motion for summary judgment, start striking factual allegations. You'd strike theories of claims or theories of recovery, correct?
To a certain extent, yes, but in this particular case, I think there's a distinction between if you were speaking to, if we were arguing that because these theories weren't addressed in the plaintiff's opposing expert affidavit, then yes, I would agree. In this particular case, though, the plaintiff's counsel specifically agreed that these allegations, as they're expressed in the bill of particulars, were being withdrawn or could be withdrawn. And because of that agreement, it's our position that those allegations, factual allegations from the bill in particular should have specifically been dismissed based upon the agreement of the parties.
Right, because I think the way the plaintiff framed it below was, the only thing that's at dispute is what happened inside the surgery when the mallet hits the surgical tool. Not before, no pre-surgery, no post-surgery issues here in this case.
I believe that's correct. Okay. If I may continue, to the point that I think there's no disagreement between the parties at this point, beyond what you've already pointed out. With respect to University Orthopedic Services, there were allegations against the group of negligence on their part, separate from allegations that they're vicariously liable for the actions of Dr. Doak. Now, on this appeal, it's my understanding that the plaintiff agrees that the direct allegations against University Orthopedics were withdrawn and are no longer a part of this case. That was not reflected on the court's order on our summary judgment motion. And I would specifically request that the order be modified to reflect dismissal of those claims. If there's no further questions, we would rest on our papers.
Thank you very much.
Thank you.
Mr. Johnson, good afternoon.
Good afternoon, John Daniel, on behalf of the appellant, Dr. Tyler Kent, Clyde Health and Children's Hospital of Buffalo. There are some overlapping issues, and as it relates to the hospital, there were claims in the bill particulars with respect to preoperative care, with respect to neuromonitoring. In fact, the bill particulars against the hospital mostly dealt with claims of neuromonitoring. There are claims of postoperative care, and plaintiff conceded below and concedes in its papers in its brief before this court that there was no opposition and those theories can be dismissed from the case. There are a couple other, and I contest their theories that were alleged that they apparently don't concede. And one is there's a claim, actually a cause of action in the complaint, and claims in the bill particulars that Dr. Doak and Dr. Kent weren't properly qualified or credentialed to perform this procedure. And Dr. Molinari in his expert affidavit expressly addresses those claims. And Dr. Doak, based on his having completed a fellowship in pediatric orthopedic surgery, was qualified and properly credentialed to do this procedure. So the court below, their decision is silent on that cause of action, and we submit that should have been dismissed as an unopposed aspect of our motion. One of the other claims, theories in the bill particulars in the court below, is that the hospital failed to implement policies regarding this surgery. Dr. Molinari addressed that theory as well as in his affidavit, and basically said that this type of event is a matter of clinical judgment by the attending surgeon, and that it's not a matter of that the hospital does not implement policies to govern clinical judgment of an attending surgeon on surgical technique in a case like this. So we met our theory on those issues. That was unopposed. In fact, I'm going to jump to Dr. Kent now, because at oral argument, if you look at the transcript of the oral argument, counsel of record for the plaintiff at the time, Mr. Goldstein, conceded that all direct claims of liability against the hospital could be dismissed, all claims. including the claim for, including the claims against Dr. Ken and the claims against Children's Hospital for Dr. Ken. And the obvious rationale for that concession for plaintiff's counsel at the time of oral argument is that there's ample proof throughout this record that Dr. Ken was being supervised when he performed this aspect of the surgery. I think, I had it written out, I think this case really seems almost identical to the Blendowski case, which was decided by this court in 2018. That case, the resident was operating a drill, and the surgeon directed the placement, the attending surgeon directed the placement of the drill, but the resident operated the drill and pushed it through the bone and stuck a nerve.
It's a question of too much force, like with the hammer here.
And I think it's directly analogous to what's happening here. And so I think in Judge, the trial court's finding that Dr. Ken was exercising independent medical judgment was, or that there was a question of fact on that, was his conclusion that maybe he didn't heed the instructions of Dr. Doak to tap gently.
Yeah, well, gently is kind of a general term, and I guess the idea there was he exercises judgment of what's gently, how hard to hit. I mean, it does seem like an awful important procedure to give to Dr. Ken at that point.
Yeah, and that's a claim against Dr. Doak. Yeah. And that's a claim. That's the crux of their argument against Dr. Doak.
And your position is that Dr. Ken didn't do something other than what Dr. Doak directed him to do. Dr. Doak told him strike the tool, but he did pretty poorly here.
And he did it.
And even if he does it poorly, you say that the resident still has no liability.
Well,
because he's not exercising judgment and doing it.
There's no proof that he even did it poorly. Because Mr. Goldstein in the.
But that's not your point. Your argument here is even if he does it poorly.
100%.
Because he didn't exercise independent judgment. He did exactly what the attending told him to do. 100%. Strike the tool.
True. Yeah. And but just taking that one step further, on that issue, at Dr. Doak's deposition, Mr. Goldstein asked Dr. Doak, well, what did you observe? And it's in the transcript. It's cited in our paper. I think it's page 59 or 61 of his deposition. He said he did exactly what he was supposed to be doing. He did nothing abnormal, and that it was the bone cracked with an unusually, unexpectedly, given the amount of it said that the bone made a unusual cracking sound.
But
given the amount of
I'm sorry, but the opposition is that the tool wasn't placed at the right angle, and Dr. Doak should have stopped it and made sure that the tool had been redirected. And
I think that is one of the claims, and that was on every aspect of that.
Because I think the plaintiff says this action could have happened even with the right force, but for the fact that the tool was at the wrong angle causes the problem here.
That's the way I read it as well. But again, that's a claim against the co-defendant, which is preserved and which is going to go to trial on it. And the plaintiff has a remedy against Dr. Doak if the jury finds that was a negligent technique. So the last issue on the motion is the question of the hospital, the issue of potential vicarious liability on the part of the hospital for Dr. Doak. And this is the only issue in the court below. If you look carefully at the papers and the transcript of oral argument, this is the only issue that the plaintiff contested in the court below at argument of the motion. And we submit it's the deposition testimony of the mom was very clear that the primary care physician referred her to Dr. Blum. And Dr. Blum retired. Dr. Blum referred the patient to Dr. Doak. The fact that Dr. Blum had an office at Children's Hospital, and that's where the plaintiff elected to go see Dr. Blum, does not create a question of fact on the issue of vicarious liability under the law of this state. The Meduba claims, the Meduba type ostensible agency is reserved for the situation where the patient goes to the hospital seeking care from the hospital, and the hospital assigns the physician. And we cite all the cases, throughout our brief, and I think I guess some notes here. There's the Muslim case, the second department case, the Nagangast case, it's a third department case, and the Passek case, which is a case decided by this court in 2001. And the courts are clear throughout the state when the patient goes to the hospital seeking care from a particular physician, whether it's someone they selected or whether they're referred to that specific physician by another provider, vicarious liability does not attach. And I would also just end by referring to the court to the Thurman case. It's a third department case, and they explicitly addressed some of the issues raised here and said the hospital is not under an obligation to tell the patient, oh, Dr. Blum doesn't, Dr. Blum or Dr. Doak aren't employed. They're independent contractors. There's no obligation to make that representation in the court. And that, so any argument that, well, she should have been told, that's just insufficient to create a question of fact on the issue of ostensible agency. And the only other thing I would add by saying...
Your time is drawing near, if you would, please. Your time is drawing near.
Yep.
You can finish up,
Yep.
please.
Yep. And that's really all I have, Your Honor. The only other minor issue is that the plaintiff mom was aware that Dr. Doak had offices outside the hospital and testified that she'd been to those offices for purposes of getting paperwork. So with that, putting that all together, it's each and every claim that was asserted by the hospital, we met our burden, and the opposition was insufficient to create a question of fact on any of these issues. And the hospital, Children's Hospital, Quite a Health, and Dr. Kent were all entitled to summary judgment, dismissing the complaints in their entirety, and we ask that this court respectfully modify the lower court decision accordingly. Thank you for your attention.
Appreciate it. Mr. Pajak.
Good afternoon, Your Honors. Beginning with Dr. Doak's motion, which I really call a housekeeping motion on his part, I agree with Justice Del Conte that I don't really look at summary judgment as limiting theories. You're supposed to go after causes of action. So while the theories of liability were being cleaned up at the discussion or argument, I don't think the lower court erred in issuing the decision it did as far as not specifically addressing those. But I believe that our brief does address, again, from a cleanup standpoint, the various sections in the bill of particulars, which we believe do not apply to the actual facts of this case. We are looking at the moment of the actual surgery, as was discussed. We're not looking at the neuromonitoring. We're not looking at the pre- and post-operative care and that sort of thing. But again, those are not causes of action. Those are theories of liability. And again, I don't think the lower court erred in not specifically addressing any of those. But from a theory of liability standpoint, we do agree that the neuromonitoring is eliminated, as is the post and pre-operative care. I want to turn to Kalida's motions here, and I want to begin with the ostensible authority argument. And I thought it very interesting that earlier today, we had another appeal earlier talking about ostensible authority. And in that particular case, I had to remark to myself, boy, my case is very different than that case. Because in order for there to be ostensible authority relative to Dr. Doak, which would then vicariously impute liability to Kalida, there has to be, from a reasonable person's standpoint, the appearance that Dr. Doak was an employee or basically employed by the hospital. I think it's important to begin this analysis by commenting that the plaintiff here, Maya, when this all happened, she started treatment when she was 13, and the surgery was when she was 15. This is their motion, it's their burden. They have not shown that a 15-year-old did not reasonably think that this doctor was employed by the hospital. She did offer some testimony, and that's in the record, where she said, I went to the hospital, I went to these doctors, I thought they worked for the hospital. What they're trying to do is bootstrap the mom's testimony and impute that sort of knowledge onto a teenager, okay? But even looking at that, let's look at what the mother said. She went to her pediatrician. The pediatrician said to go to Dr. Blum. There's the specific referral to Dr. Blum. But Dr. Blum is not a defendant here. It is Dr. Doak. So she goes to this clinic at Kalida, at Women's and Children's Hospital, where she sees Dr. Blum. Dr. Blum apparently is going to retire. Oh, here's Dr. Doak at the clinic. There's no specific referral to Dr. Doak from the pediatrician. He was at the clinic, and she was just segued over to him. So what is she supposed to think from a reasonable person's standpoint? This guy works for the clinic. She goes to this clinic through the front doors of the hospital. There's a sign overhead that says, orthopedics, this way, and you follow the arrow. Every paper that she gets is from the Women's and Children's Hospital Orthopedic Clinic, including the consent forms and everything else. So she has every reason to believe.
I'm sorry, let me stop you there for one moment. Other than the documentation she receives that has basically on the hospital letterhead and the paperwork, what else did the hospital do here? Did the hospital do to give your clients the impression that Dr. Doak was the hospital's employee or the hospital's agent? What did the hospital do?
I think it's the entire setup of the clinic. And again, I talked about the signage, I talked about the letterhead, I talked about you have to go in the front doors. There are clinics that you have to go in through a separate door, giving the impression that it's not part of the hospital.
No, so the impression I understand, but specifically, what did the hospital do to create the impression?
That is what they did.
By allowing the physician to have an office or a clinic inside the hospital, they're giving the impression to everyone that that clinic and that physician is an agent of the hospital?
And allowing that clinic and that physician who is not an employee to do it on hospital clinic letterhead, call this phone number, they would call the hospital phone number. All the treatment was at the hospital. Now, the one visit to UBMD where the mom had to drop off some papers, they're trying to focus on that and say, aha, she had to know that he was actually an outside physician. But given the totality of the evidence indicating that he was a member of that clinic versus one visit just to drop off these papers at UBMD Orthopedic, I don't think a reasonable person, certainly not as a matter of law, would then conclude that he was not an actual employee of the hospital. And I think the trial court properly concluded there were questions of fact here on that issue. And again, I would point the court to one case which I thought was most instructive. That's that Syracuse versus Dio case. And that's where the person called the eye clinic. They just called the eye clinic. That was the evidence of ostensible agency. And the court said that was enough for a question of fact. It looks like we have a lot more here than in the Syracuse versus Dio case. So again, I would submit that the trial court got that issue right. Turning to the issue of Dr. Kent and the issue of whether or not he acted with independent medical judgment. Now, the Blankowski case that we've been talking about, which has been briefed extensively, that's the drill case that we talked about. The drill case is very different from what we have here. And the reason it's different is because in that particular case, there was evidence that the attending physician was hands-on. He told the resident the angle of the drill. He actually, at the very end, the attending told the resident, and this is in the case, when to stop drilling. And it was the fact that the resident did not stop drilling soon enough that caused the nerve damage to the patient's hip. Here, we don't have such explicit direction. We have vague references to tap gently, like Justice Loney said, whatever that means. Be careful. Well, that's a nice word of advice for an attending physician to give a resident who's never done this procedure before. What exactly does that mean?
Weren't they working side by side doing different things at the same time?
I'm sorry?
Weren't the two doctors doing different procedures at the same time on the same patient?
Yes, they were.
They were like, one's working on one side, one's working on the other? Do I have that right?
I'm not sure on that point, Your Honor, honestly. I'm not sure. But I want to contrast, though, the beginning of the procedure when they were placing the pedicle screws. If this had happened during the pedicle screw placement, because again, in that particular part of this procedure, the testimony is that Dr. Doak actually had his hands on the resident's hands. This is how you do it. This is how you move it. He's touching the resident. I'm not saying that's always required, but that's what happened here. Contrast that to, here's a hammer and here's a chisel, and go at it, and be careful. That resident was exercising independent judgment as far as how hard to hit.
When Kent was doing the tapping with the chisel, we'll call it, it sounded like Dr. Doak was performing other procedures on the same patient, like wasn't just watching Kent.
I agree with that.
And that's a little different than if you're supervising somebody, you're, okay, do this, hold the drill, I'm doing this, you do that.
I see what you're saying. I agree with that. No, he was not just sitting there staring, watching him do it. He was doing other things. Again, allowing Kent to exercise his independent medical judgment.
Let's just be clear here. What is the judgment that Dr. Kent made that you believe was independent? What judgment? Not act, but what judgment?
What kind of force to utilize on the osteotome, and that's what the trial court found. Each strike of the osteotome is an independent medical judgment. How hard do I hit it, which means how deep do I go? Do I go too deep? And Dr. Doak at the end testified that it went too deep and it hit the spinal cord, resulting in her being a paraplegic. So each of those strikes is independent medical judgment. Now, on the issue of the discussion at oral argument regarding where counsel at the time mentioned that, I guess it's unopposed as far as Dr. Kent. You heard that argument just up here. In getting ready for our argument, because that's obviously something I assume the court would have some questions about, there's a case called Liberty Taxi Management, 32 AD 3D 276, which says that even an unopposed summary judgment, it doesn't mean it's automatically granted. It's still up to the court to search the record and make sure that summary judgment is entitled to that particular moving party. And here, it's clear from the discussion at oral argument that Justice Licata had some significant concerns about the independent judgment. He was concerned about what Dr. Kent did, wasn't sure about exactly what he did, and wanted to look at the facts further. And then in his written decision, he thought it was a close call based on the independent acts, the striking of the osteotome and that sort of thing. But he said, this is summary judgment. And on a summary judgment, the close call should go toward denial, not granting. So for the same reason, this court should affirm Justice Licata and deny Kalai's motion.
Thank you.
Thank you.